interested in, I have a 1914 common law procedure book, and I found a link to that online. And I think part of the problem with us attempting to convert a court action to a common law court of record has been the pleadings themselves. The form of the pleadings, we've been demanding a common law court of record, but the form of the pleadings have still been in the legislative equity civil side, because under strictly common law, your claim would be trespass, case, replevin, assumpsit, special assumpsit, along those lines. So what this book does, it's about 900 pages. Trover, replevin, detenu, ejectment, debt, covenant, those are the forms of actions. And then the answers would be demurs, special demurs, joint and several demurs, effective demur, and openings on the record. And then what this book does is it went by case law from, I'm assuming because I believe this is California.
And what's the name of the book, Ben?
I think I sent you the link. It says Cases on Procedures Annotated, Common Law Pleading by Edson, Edson, R. Sunderland, Sunderland, and he's professor of law in the law department of the University of Michigan, Chicago, Callahan and Company, 1914. And so what this book does is it teaches you what the forms of actions were and what are applicable to the forms of action, because you could have a form of action for, say, case, and you had all the elements correct: the venue, the entitling of the declaration, the commencement, the conclusion, the cause of action, the necessary allegations, the place, the name and identity of persons, the title, the authority, and you could have all those right, but you filed a trespass, and it should have been case. And so you have to form your proper declaration with the proper elements and the proper type of action. And I was thinking, he was on a call where he was describing, Karl Lentz was on a call where he was describing when he filed his claim for damages in federal court, the clerk converted it into a Title 42 action because, as he said, the clerk didn't know what form of action he was trying to file. And so had possibly he filed his declaration in one of the official types of forms of action, they would have known right off the bat. And so Chapter 4 gets into the declaration and the elements that are required to be in the declaration. Anyhow, and then and it all goes by case law of the time period to show the errors or a correct declaration, or whatever the issue you had.
By the way, that's available online.
Yes, it is.
Ben, you're on the phone, right?
Yes, sir.
Ben, I'm talking about Ben, the speaker. You're on the phone, right? You're not on a computer?
No, I'm on the telephone.
Well, that KL Direct B, he needs to talk to you on the phone.
Yeah, I'm on right now.
Okay, good.
No, when I did file my, I'll give you the link from my lawsuit that's on PESA, and I did file on my cover sheet. I filed at federal court at the District Court of the United States in Middle Alabama, and on the right-hand side, I wrote trespass.
Oh, there you go.
Then I used colon, and then my cause of action, which was not a cause of action, it was just a declaration of wrong, was forgery. And I charged him with uttering a forged instrument that interfered with my administration of my property without rights.
Right. Yeah, I'm familiar with your action because I've listened to you on your calls, and I think I was one of those. My email is kelwindy. I started emailing you right after your first call, and then I was the guy that got Tom on your back, Tom Murphy.
Oh, I love that guy. We talk to him for hours every day. He's great.
Yeah.
He's crazy, but he's a good guy. He's
right. I actually have been emailing him back and forth about this book, but for some reason he was having a hard time understanding the application. And so when I started pointing out, just study the table of contents, because it's teaching you how, by the cases of the time period, how to form a proper claim and trespass, or, by example, an improper claim and trespass. That was each of the different cases in there, or a proper claim and case. And then Chapter 4 talks about the required elements of the declaration.
What's funny is the reason why he's not going to listen to you is because I've made it extremely simple for him. When you see common law written down like that, what you're reading out of, what you're reading is Old English common law. So when you're reading the style that they acted in England for hundreds of years.
No, this is American. This is all American case law.
Right, but that's what I'm saying. They try to use English case law. They try to use English common law here in the States as well. Because American common law is, you've always heard that a million times, common law is unwritten, right?
Right.
Okay, so now all of a sudden if you're reading a book with all kinds of common law that's written down, obviously it's not common law, it's a form of common law, it's English common law. English common law is the written common law. Our common law is whatever's the custom of the people who happen to be native to the land. Like if the people smoke peyote in Arizona and there's a federal law that says you can't give children peyote, well, they'll just say, well, the common law of the land of the people who live within this land is peyote smoking when they're 3 years old. Now, you can say, well, it's all kinds of codification on the rules of Health and Human Services Act that you can't do that to a minor child. They'll say, you know what, stick it in your peace pipe and smoke it. You know, we don't care. This is our customs. This is our common law. This is our land. This is our people. We'll do as we wish.
Right.
And there's nothing you can do to stop us.
Well, I think another problem that we've been having on, say, that you've already got a civil action brought against you by an administrative agent, and you're trying to demand common law, and people are going, isn't it the 7th Amendment that talks about at suits in common law? Well, that's the very problem, is that suit brought against you was not in common law. So here you're demanding that 7th Amendment restriction on them that at suits in common law, and it says right in there, in suits at common law, where the value and controversy shall exceed $20. Well, the problem is they're bringing you an equity civil legislative action, not a common law action. So the only thing you could possibly do is bring it back through your declaration in proper form of substance in the answer, or a counterclaim to bring it back into that common law court of record that's demanded in the state constitution, but is not set up in the 7th Amendment.
Okay, the easiest common law approach to do. You're gonna love this, because I have little old ladies all over the country saying I can dance when I show them how simple everything's done on one page. Like my lawsuit was done. The actual claim of wrong was one sentence. The actual lawsuit was 1 page. So when I came out of the federal marshal's office on Wednesday, they said Alabama was having a little bit of concerns of how I was following and going through a common law. So they asked me on Monday to come down to the marshal service. So they wanted to come speak to me. So I said, look, let me wrap up my farm, take care of my animals, and I'll come meet you folks. You know. So I brought my lawsuit down to them, and I said to them, how simple can this be? I said, all I did was make one sentence on my claim of wrong. I said, forgery, the utterance of a forged instrument to interfere with my rights. There you go. That's it. I said, that's my whole lawsuit. And I said, and the whole thing I made under the whole entire thing is that it's under the common law. It's a trespass, and the only cause of action is a forgery, and they don't know how to deal with it. It's too simple.
Right, and then you were saying on the call that you were simply going to wait the 21 days because they would never respond, and then you were going to have the clerk enter the judgment, and then you were going to go sell the judgment. But the problem is like Gene has said, that they've gone all over the place, and nobody will buy those judgments unless they're actually signed by the judge.
Well, it has to be signed by the clerk of the court.
Well, I understand that, but the problem is that the agencies that buy them won't buy them unless they're signed by a judge.
If it's a default judgment, there was no trial necessary. So if there's no trial necessary, all it is the clerk of the court is saying.
Right, I'm not arguing. I understand that perfectly well. What we're saying is that you may have a hard time actually selling that, because they, in order to buy them, they want them signed by a judge.
Well, then you're saying that they want them to be signed by a United States District Court judge, not a District Court judge.
Right.
Right, so this,
well, where are you in that? Because obviously the 21 days is long past.
Right, so I showed the U.S. Marshals what I was doing. Oh, they love me now. They gave me like a green light to go, because you were jumping the gun a little bit with the bonds and stuff, because that's paper terrorism. You can't interfere with the steady, I'm trying to think of the word that we use for things like that. You can't interfere with the regulation of the steady.
No, all I was talking about is that in the General Revenue Act of California, they created an excise tax. I'm not saying that the excise tax destroys the bond or anything. I'm just saying that the 1857, if you partake of a negotiable instrument, there is an excise tax requirement to be paid. So I'm not saying you're going to pay anything with the bond or discharge anything with the bond or anything of that effect. I'm simply saying that there is an excise tax, and that guy in Washington, when he paid his excise tax to his county treasurer, the treasurer notified the bank sent him 2 releases of lien, and he did not pay off the note. So that led me to believe and ask the question, is it in fact that the lien is created off failure to pay the tax? Because in the mortgage contract it says you're responsible for the taxes, but it didn't tell you which one. So they're leading you to believe it's property tax. But this act says that private property is not taxable under property tax. So the only thing that would be left would be the excise tax on the creation of the negotiable instrument, which is a benefit of government because they created those out of legislation. So when
that's
control.
I was talking about how to move something through a court. I'm sorry about that. You must have misunderstood when I said bond. I said to the federal marshals, I said what I'm going to do next is I'm going to have them sign these judgments, and I showed them the 2 judgments I wanted to sign. I said, now I'm going to send them down to the clerk's office, and I want the clerk to sign it. That was the full judgment, and I just want them to deliver it back to me in 72 hours. And I said to them, if they don't do that, then I'm going to say to the district court or the United States District Court, are you a public officer, or are you a public employee, or are you working for a private corporation and you're just a legal instrumentalities to the person known as the United States? Then you don't have to be bonded. So, just like the IRS doesn't have to be bonded. They're not bonded public employees, they're not bonded public officials. So if I'm trying to go after their public oaths, or I'm going after their bonds, they don't exist, so I'll be wasting my time. So I said to the Marshal Service, I said, you're going to get a complaint again from the district court down there that I'm asking them for their public oaths to be, put on a public record that I have access to them, and then I'm going to ask them for bond information. They're going to tell you that I'm committing paper terrorism. I said, I'm not doing that. I said, this is your law, this is their law, I'm doing it step by step by step, and I showed them all the steps that I'm still going to do. So like the guys were looking at the steps too. Thank God that, like I said, the marshal guys was like, and then you're going to do, I said, this is the book I got it from, I got it from your website, I got it from the uscourt.gov website. I said, you see that on the very first page of uscourt.gov website, what does it say? All federal courts are Article 3 courts established under the Constitution.
And courts of record.
Well, that's what it says. I said, right there, I said, well, let's course, Juris, Section 344 says all federal courts are courts of record.
Well, I thought it said that on that website, too.
What I said on the website, too, it said all state courts are common law courts. That's what it says on that website. The website posted to you guys. So the first thing it says is federal courts are all federal courts are Article 3 courts established under the Constitution, and it says all state courts are common law courts. And then I said to them, if you look at Chorus Juris, not Chorus Juris Secundum, Chorus Juris, the first one, it says the characteristic of a federal court. Characteristic, all federal courts are courts of record. And then I said to them, let's look at Black's Dictionary. What's a court of record? Only moves under the common law. There you go. Only moves under the common law. So I'm moving in a federal court, which is a court of record, and all courts of record are under the common law. I said, and I showed him a map. I just sent it to Tom Murphy and somebody named Greg Grupa from Chicago. I showed him a world map that there's only 5 countries left on the planet that common law is the predominant law of the land. It's United States, Canada, Ecuador, India, and Australia. Everybody else is civil. So when anybody tries to attack me, I said under the civil code, I just drop the map on the desk and say, what does that say? The common law is only in America, Canada. That's actually a picture of it. It's all in colors and it looks pretty. And I said, so I'm moving this. I have the authority to control the jurisdiction to move it over to the common law side. This is going to now be a common law claim. No more administrative complaints. Now I'm moving right over to the common law. And how can I do it? Look, UScourts.gov clearly says all federal courts are Article 3 courts. So when I hear a lot of these free men in Montana screaming up and down on the radio, I said that to the U.S. Mall Free guys. I said, look, I apologize. Back in 2003 to probably about 2008, I was just as crazy as these free men were using all this, there's no such thing as Article 3 courts anymore, and I got to sign everything like Isaiah or son of Ezekiel and free men and flesh and blood. I said, all my lawsuits are 1 page long now. I said, scary. I said, they read their whole lawsuit in like 10 seconds. They're like, that's it? That's your whole, I said, whole lawsuit. I go, are you kidding me? I said, no, does this sound like anything threatening on everybody? Like, no. It's one sentence. I was like, I described me. I described the defendant. Like me was like maybe 2-3 sentences. The defendant was 2-3 sentences maybe. The claim was, jurisdiction was simple. There's a diversity of the party. The parties are diverse. And the matter of controversy is more than $20. And the next line was the actual declaration of the wrong was forgery. They added a forged insurance, which is interfering with my rights. And then order that I put at the bottom is that I order, immediate compensation of whatever, $1 per every second my rights were interfered with, and that the other judgment was going to be signed that there is a forgery and that the forged instrument is to be noticed by the world as a void document, a void instrument. So I said, that's it. I said, it's simple. I said, how that for you guys to read? I said, look at the front cover. What does it say? Like Karl Lentz versus like this, like DHL, it's like CPS or everybody else around the world. I said, what does it say on the other side? It says what the cause of action side says. It says trespass, and then it says what? Forgery, and what does it say at the bottom? Verified. That's it. What's it say underneath there? Trial by jury, and magistrate only, and I'm trying to remember, it said one more thing. The trial by jury you always want to say. You don't want a jury trial. There's a huge difference between jury trial and trial by jury. And then you want to make sure that you have magistrate only, court of record, magistrate only, and that way the magistrate, everybody knows Billy Lawton's thing is like the 4 elements of the common law, court of record, court of record moves under the common law, you can hold people for contempt. The magistrate is independent of the tribunal, and what's the 4th one there? Oh, keeps a perpetual record of the proceedings,
right?
Perpetuity, and a seal.
Right.
Go ahead. No, so my lawsuit is incredibly simple. It's 1 page long. So when I say these 4 guys, stop writing these 2-page lawsuits, 3-page lawsuits, 500-page lawsuits. I said to the marshal guy, I said, look, I was guilty of that. In 2003, I wrote like a 300-page lawsuit. My sister was standing right there. I said, you're not writing that nonsense with me, don't you? And she said, yeah. I said, I thought I trimmed it down like 5 years ago to 100 pages. Now I'm down to 1. I said, I make my claim. Now, somebody has to come into the other side with the man who's going to say that my claim is not true. Good luck with that.
So I think part of the problem is here when we have an administrative agency that's bringing a claim against you, that is a civil equity legislative Article 1 court. And so here we're taking and using a civil legislative form in pleadings demanding a court of record. Well, they're giving you an equity legislative court of record. It's just not a common law court of record, and I believe it's the form of the pleadings that makes them unintelligible to the court because they're not in proper form and substance, like what you're suggesting that you did with your suit. But of course, the question would be, can you, with a simple answer in a common law court of record form and substance, convert that action over? And it should be, because you were never subject to the original act to begin with, because it only had application to a contract or an artificial entity.
Right, and like I said, it's very simple. Like I said, when me and my sister were waiting in the marshal's office, it would pop out. I thought I was actually going to go to jail. I thought I'd never come back to see any of these animals or this farmer again. I really did. I said, if you guys, because I figured they were a little nervous because I'm beyond too simple. And my stuff is so amazing, like so simple, it's scary. So what was funny is I said to my sister, I couldn't imagine that poor magistrate who's going to try to arraign me. Oh my God, they're going to have me like sitting in some federal prison for 100 years waiting to get a contract over me because.
Wait a minute, why would they be trying to arraign you? Did they file some type of claim against you for filing your suit?
Well, what I'm saying is, I pity the fool if they did try to charge me with a crime on Title 18, because how in the world are they going to get me to contract with the court? I'm going to say, I'd say, may I have a piece of paper and a writing utensil, please? Because I only answered court in writing. And I would have made some very simple thing. I would have said, what is the nature of the person whom this court seeks? And they would have had a coronary. Because nature is defined by God. So God defined me as a man. So as soon as they say that there's a man present in court, they're realizing they're a judge, or they're just simply a magistrate. They have no jurisdiction over a man. And I'm going to say, now, if you recognize there's a man in court, good. This is a common law land, right? Good. This is my wish to move this matter over to the common law. I said, if we're in England or France, and I actually did that to this marshal guys. I said, see this map of the world? I said, see everything else is blue. Over here we're orange. I said, now if we were in France, I'd be screwed. Because the civil law is what I'd have to answer to, and I'm guilty, and I have to prove myself innocent. Thank God we live over here. You see where I colored it orange? I said, this is common law. They have to prove their case against me. And they can't make a claim. The only thing the government can do is make a complaint. They can't make a claim because only man can make a claim. The government can only make a criminal complaint. They can't make a criminal claim. So I hear all these guys saying, oh, we're going to make a civil complaint. You guys are crazy. Because that's what governments do. You're dropping your status. When you go to a complaint, you're dropping your status down from a man to a fiction in law, because a complaint is done by government entities. Governments can't make a claim. They don't. You never heard of such a thing as, well, there's a criminal claim against me. There's a criminal complaint, issued against you.
Well, but it depends on what type of remedy you're seeking. There are legislative equity, statutory claims that you could make if you understood them. So it just depends on what option you want to take, really.
I want the one-page option, the two-sentence option. I just want to state my claim, make my claim, and say, is there any man going to come forth to say that my claim is not true? Does anybody else have a superior claim than me? If not, the government can't make it.
And that's the whole question on dealing with these administrative agencies when they're coming after you. If they don't have an original contract that you sign into knowingly, intentionally, voluntarily to receive a consideration with full disclosure, then who is the real party of interest that was injured that filed the complaint, a verified complaint against you? So
Even
it's got to be either way.
Even, like I said, even if it's a verified complaint, that's silly. You'd want to make a verified claim against me.
No, I'm talking when they're coming against you, not when you're coming against them.
Even if you enter into a contract with a fiction, like say you made a contract with your television for some reason, I don't know, you could pop yourself out of the contract. And like I said, maybe you heard that explanation I gave one time. What happened if you and I were on an airplane, and we're in Al Jazeera Airlines or El Tel Aviv Airlines, and we're flying over to Israel? And all of a sudden some crazy Palestinians get up and say, everybody who's a U.S. citizen, come forward so we can slash your throat right off the plane. Now, are you going to exercise your right to be a U.S. citizen? Say, they asked me if I'm a U.S. citizen. Yeah, I guess I'm a U.S. citizen because I got a Social Security card. Yeah, I guess I'm going to get my throat slit thrown off the plane. Now, you have the right to exercise. It's a right that you can exercise, just like you can exercise your left hand and right hand if you want to. You don't always have to be a U.S. citizen. You don't always have to exercise your left hand or your right hand. It's a right that you may choose to exercise when you feel it's at your convenience or your benefit. Now, if I'm not going to get a benefit by being a U.S. citizen at this particular moment in time, how is they going to prove in court that I'm a U.S. citizen? Good luck with that. Who's going to stand on the other side and testify as a fact that I'm a U.S. citizen? An attorney can't testify in court. And Clayton Cherry taught me this, because if you look into Google, there has been no New York State foreclosures on homes for like the last 3 or 4 years, because these guys, like Clayton Cherry, said in court, we're going to need to have the representative of the bank take an oath to testify in open court on the witness stand that everything he's saying is true, or it can't be entered into the record. There has been no foreclosures in New York State for like the last 3 or 4 years, because the Supreme Court judge in New York said he's absolutely right, or his little group is absolutely right. An attorney can't testify to a fact. He has no first-hand knowledge of any of the events that happened.
Well, they brought the bank president and manager here on a case of my friend and did just that.
They took the stand and they testified under oath of affirmation that they witnessed the closure, the signature, the mortgage, everything, that all the paperwork has been in their possession at all times.
Well, I don't know what all the questions were, but yes, they led them to that testimony, you bet.
Well, like I said, what Clayton Cherry did was great. The way the man explained it, I would explain to a lot of people, the first thing you ask a judge is, is it true that for evidence to be, and facts to be noticed by the court, it has to be come in on first-hand witness, and that both parties must be sworn in? And he's like, yes, that's true. It's like, okay. Well, for an appeal purposes, may all the evidence or notices or facts be entered into the court, can we please put it on the record under sworn oath of affirmation? And the judge will say, well, absolutely. He says, okay, well then, I would like to swear on the oath of affirmation that everything I'm saying is true and nothing but the truth, help me God. Now, I want the other side to swear themselves in. And then he's like, the attorneys can't do that. It's like, well then, who's going to swear in for the other side? Well then, nobody's showing up on the other side, so I guess I win by default. He says, so that's how you knock the attorneys right out of my sister did it in her divorce. And like I said, she told some other man today, she said, you know what, that was the first case I ever went into court and I won. She said, I've been doing worse and worse and worse as time has gone by because I didn't know anything. And the first time I went to court, I just listened to my brother, and I did it exactly the way he told me to do it. She says, now I'm trying to figure out a way to make it better, what he tells me, and I'm just starting to lose now. Because I just won't stick to, when she appeared in court, the judge lady, they're all called Supreme Courts when you go to divorce, it's up there in New York. She said the Supreme Court lady said to her, it's time to introduce the parties. She said, who are you? She said, well, my name is Karen, and I am my person. I am my case now before the court. So then she said, okay, you're going to be represented by an attorney. She says, my name is Karen Garner. I am my case now present in court. And she says, so are you going to self-represent it? Do you want an attorney appointed to you? She says, I am Karen Garner. I am my case now present in court. And the judge said, okay, I understand. So then they introduced the other side, and her husband was like a rich guy. He's got a quarry, he's got a scuba shop in Long Island, he's got a ranch in Montana, he's got big bucks. He had 3 attorneys. And they all introduced themselves. So my sister was the moving party, so she went first. So the judge let her say her thing. And as soon as the other side stood up, the ex-husband was smart, got a female attorney because it looks better, a female attorney going against a woman and a male attorney going against a woman divorced. As soon as the female spoke, my sister said, I object. And the judge was like, well, it was your turn to speak, now it's their turn to speak. Didn't my husband did he get a sex change? Because it sounds like there's a woman talking over there. And she's like, no, that's his attorney. He's like, ma'am, our attorney's allowed to testify? And she said, if she has any first-hand knowledge, she has. Can you ask her if she has any first-hand knowledge of this? He says, do you have any first-hand knowledge of this? Any events that occurred during their marriage together as husband and wife? She's like, no. He said, then I object to this woman speaking on anything in this matter, and I demand that she not be recognized by the court, or any facts or evidence that she's bringing into the court can be taken notice by the court. And the judge said, okay, duly noted. She said, the attorney, she said, sit down. The attorney started to say, but ma'am, she said, you know the rules, now sit down and shut up. So then her husband had to get on the witness stand, and she just beat him like a piñata because he didn't know when to shut up. He just started talking, and she said, I cleaned his clock. And I'm telling you, that's all you have to do. When the judge realizes, you say to the judge, the nature of the person that's before the court, the judge is confident. It's when you start to try to get away from other than just saying, my name is, what's your name, sir? My name is Karl Lentz. What's your name? I never get your name, Mr. Talk Show host here. Your name, what's your name?
Ben.
Ben?
Yeah.
Okay, hey, Ben. What it is like you just say, Ben just says, I in my case am now present in court. And that's all you say. And the judge will say, well, you're going to represent yourself. I, Ben, in my case am now present in court. I'm now here before the court. You just say the same thing 3 times. I'm going to ask you 3 times. I swear to God, it's true. They do it 3 times. And then they say, okay, we understand. That's all you say. I, Ben, in my case am now before the court. I present my case to the court. There you go.
And what does that do? Let me ask you that. I mean, I understand what you said there, but exactly what does that accomplish when you say that? What does the judge understand?
The judge understands that there is a man present in court, and that the man is moving under the common law, and that there is no attorney present. You're not pro se. You're not some crazy jury jurist, whatever. You're not any of this crazy nonsense. So the judge realizes that now you are invoking the common law.
I understand.
You and your case, your suitcase, you're packing all your evidence and notices and everything else. You're packing everything into the court, and you just want the court to take notice that it's a man present in court with their case, and you have evidence and stuff. But like I said, the best way to do it is, like I said, Mr. Cherry, I give credit where credit is due, just like they would delete the a little while ago. And Mr. That's where you guys can find him on Angela's old talk shows, talk shoes. His name's Clayton Cherry, and he just asks the first question you say to the judge, Your Honor, is it not true that for any statement to be deemed admissible evidence, it has to be under oath of affirmation? And of course, the judge is going to have to say yes. And then you say, therefore, before we proceed, it is my wish, because we make a wish, to be sworn in through affirmation. Therefore, there can be admissible evidence pressed upon the record in the event of and for appellate review if it is necessary. And it is my wish that the other side do the same. So there you go. And so right there, you done it. You neutralize the other side. There's nothing they can say.
I have a question.
Unless you're going against another man, then you're in trouble.
I have a question.
What's that? Okay, do you want to ask a question? Go ahead.
Well, I hate to interrupt the flow, but do you have examples of that type of wording posted anyplace? Or is it available?
I got it from Clayton Cherry. I did the transcript of his thing. I mean, yeah, sure, I could send it to. You could send. This man Ben, he sends me emails, and I only have an email address for talkshoe people only, and I don't. It's KL Direct. It's just like you see on the screen, KL Direct TV, but with the number 2 behind it. So it's KL Direct TV 2@gmail.com. And if you I answer questions like 1, 2, 3 o'clock in the morning just before I go to bed. So if you send me something, don't think I ignored you. It's just I don't read any of this stuff until really late at night until I'm ready to go to bed.
Is there any way you can send it to Mel?
I can send it to what?
To Mel?
Yeah, I can send it to you, man, and then you can just send it to whoever you want. That's fine.
No, to Mel. She's the one that was talking earlier, the female.
Yeah, that's fine. Anybody who wants to, you know my email address, man. You could use. I write back to you. I write back to everybody. You know, I'm not one of these guys who never write back. I said you can call me and write back to me. I talk to, like I said, Tom Murphy.
If Ben could send it to Mel, Mel can get it to Gene and everybody else.
Yeah, it's true.
I can write you, I guess. You said KL. Would you repeat the email address, please?
Yeah, no spaces. It's like K like Kansas, L like Larry,
Mm-hmm.
you know, DVDRECTV with the number at gmail.com.
Okay, and I'll request the transcript that you were talking about that you wrote out.
Right.
Correct?
It's really simple, and like I said, this is great. This knocks all the lawyers out of the picture. This stuff that I'm saying will not work in common law when it's a common law contract between man and man. This is not a loophole to get out of that, because this only deals with administrative government officers coming at you, or attorneys coming at you for credit card companies. Or she did it with a credit card company, worked fantastic for her. She did it with a real estate company, worked fantastic for her. It just knocks the other side right out of the box. There's nobody who's going to show up on the other side.
I have another question. Is that a remedy for a wrongful foreclosure in a federal district court?
Well, wrongful foreclosure, like I said, this is what Clayton Cherry.
No, well, hey, it wouldn't be, because if you took it to federal district court, it would be you taking that claim to federal district court. So the application of this would be if an attorney was bringing a claim against you without having a real party of interest. The real party of interest is only the party that can testify against you. So the attorney can't run any type of claim against anybody. They have to have the real party of interest there to move the court.
I understand. But if all that is passed, is there still a remedy if the judgment for foreclosure has already been issued with using this?
That's an easy one. Who made the motion? Who motioned to court for the judgment of the foreclosure? The other side?
Yes, plaintiff attorney.
Everybody knows this one. I've been saying it like a broken record. Who did I get this from? Richard Cornsforth. Everybody knows Richard Cornsforth, right, Ben?
Yep.
Yeah.
Okay, great. What's the case he uses that works like a champ all the time? Gets rid of 99 summary judgments against everybody, against the man, when it comes from an attorney? Trinzi versus Pagliaro, 1965. That's the one that voids every single judgment that's ever been moved, either by a motion or summary judgment by an attorney. 99% of every single judgment is void on its face. If it was only, if the court took notice of an attorney's motion for summary judgment. Of course, only a man can motion the court, not an attorney.
Huh. Okay.
You listen to Richard Cornforth's thing. It's a really long, boring thing. It's like secrets of the legal society, secrets of the legal industry. There is a transcript out there on like script, like SCRIB. So when somebody says, "Oh man, that guy goes on for hours," talking about silly stuff, it's like, look, there is a transcript on script. You just go on the script website and you type in Richard Cornforth. I even posted it. I took the transcript and I posted it to my account on script. So when people say, "Oh man, he talks on for hours," it's like, look, it's a very simple line. You go into that Transit versus Pagliaro, and it simply says, if an attorney motioned to court for a summary judgment or default judgment is void on its face. It's that simple.
Now, do you take that back into the original court, or do you take it to an appellate court and
no, don't ever go to
after the fact?
Nope. You just go in, and every case can be overturned. It's so funny. If you hold common law court like somebody who's got so handsomely like this, number 10, hi ma'am, hi sir, that's okay. I like when people bash me on those bubbles or bash me on the calls. That's fine. I like it. I'm from New York. I'm a glutton for punishment. So if you understand that you're a man, and if you understand common law, if you read the Judiciary Act, oh boy, the lawyers are going to hate this one if they hear me saying this one. If you read the Judiciary Act of 1793, Clause 31, if you did wrong, there's no statutory limitations on when you could bring back your claim or void or overturn a claim if you believe you defrauded or an attorney forwarded a motion for summary judgment. There is no time limit on a man. Not only does that Clause 31 say that in that act, your children can bring it up. Their children can bring it up. Their children's children's children can bring it up. So when you hear these statute of limitation nonsense, and like I hear some stupid show, A Handle on the Law, and he always says, oh, 2 years went by, oh, 3 years went by, oh, 7 years went by, oh, 15 years went by, that's too long. Bull. In common law, there's no such thing as a statutory limitation, because that's called a latch. Man can't be latched. Man isn't bound. Man has will, and he can do whatever he wants at any time he wants. They can't create a way to bound us. It's like everybody knows, what is that one? Article 6 of the Constitution, Clause 2 and 3. Everybody knows that all state and federal employees and judges are bound by their oaths to the Constitution. Well, we're not bound anything. We're not latched anything. So when you hear the statute of limitations binds us or limits us, no. It binds attorneys, it binds like the judges, but it doesn't bind man. Nothing bounds man. Man is like a representative of God on this earth. Nothing bounds man. So the nature of the party is man. Once the court realizes there's a man present, they know that they're talking to their superior. Man has created the court. Man created the legal system. I'm just a representative of my great-great-grandfather who created you, dude. And they realize.
Wouldn't that simply be either a writ of error or a void judgment then?
That's what's great. You see, you're thinking good, but what you got to do is you say compare that with a void judgment, or compare that with what was the other thing you said?
Writ of error.
Right, because that's Dean Clifford really liked. I don't know if you heard me talking to Dean one day on his show. Dean says, lovely. I said, Dean, I watch your videos. I said, you're good. You're going to go places. I said, but you got to control your little temper thing you got going on. But let me toss you a little nugget here. What you're doing and where you're going to fail, I said, because when you start stealing, theft, intellectual property, and you start relying upon their codes, their words, their terms of art, that's theft. All that stuff that you're using is copyrighted material. You can't use that in common law. They see those legal terms coming across your paperwork, they're going to immediately take you over to civil side, because if you're a citizen, you could use statutes, and you're a big member of their family, and you could get away with using their stuff. But if you're saying you're an alien and you have unalienable rights, and you're not part of this, and you're foreign to them, and you use their intellectual property, they're going to charge you with a crime. I said, so instead of charging you with a crime, they move you over to the civil side to protect you from yourself. So when you use words like writ of error, that's like a legalese term in art. So when you say, I believe I've been done wrong, or I believe, of course a writ just means to write, or it means an order, a writ of error. Say, I order that something was done in error. So what you could say is, I order, something was done, and you have to word it like in the common terms, like the common layman terms, like an error occurred. compare that with writ of error. And then you put it in a four-corner bracket because you don't want that to actually be officiated paper, but use that little like CF. Compare that with writ of error. So you don't use their terminology, because then if you speak legalese, they can speak legalese. You always want to keep it in the common language of wherever your custom native is, your Peyote people or whatever. You don't want to start speaking legalese. You want to stick it in your native language, the common plain language. You don't want to start thinking fancy and using big fancy words and big. Like I said, I'll send you my one-page lawsuit. You say, "Holy cow, this is so simple. It's scary," because you keep it in simple, plain language. Because you flatly say to the judge anytime they talk to you and you put it in writing, you say, "I don't speak legalese. I don't know what this code 73256 is. This is some sort of crazy code you're coming at me with. Is some man making the claim that I did him wrong? Just give me time to settle this matter on a private side with the man. I'll be more than glad to come back if I don't, but I'm almost sure I'd compensate any man for any wrong that I do to him. Who's saying I did him wrong?" It's like, well, nobody's saying you did him wrong. Well, then you don't have a case against me because I'm the victim. I'm on the common law side of the court here now. You got me on the wrong side, and that's, believe it or not, you can Google the word wrong side of the court, and it'll say exactly what I'm saying. It's when they're trying to bring you over to the civil side and you want to get back over to the common law side. You just tell them you got me on the wrong side of the court. It kind of sounds too simple. It's the wrong side of the court. But actually, that is a legal term, so you got to be careful. You can say, "Can you just get me back over to my court?" And then you can do the full corner thing. So I'm on the wrong side of the court. You got me on the wrong side of the court. So you just get back into your original jurisdiction. It's called consuance. I'm trying to how to spell that. CONSUANCE. You're making a claim of consuance. Just saying somebody, like you heard, like you described me, somebody took my personal injury claim and they converted it over to a civil rights complaint. And I just was going like, "Hey, I filed a claim of consuance. You got it on the wrong side of the court. I demand that you bring it back over to the common law side in which I filed it through the Executive Court's office. Nobody had the right to practice law and represent me and convert my claim over to a complaint." So you file a claim of consuance. And all consuance means is what I described. Somehow this got over to the wrong side of the court. Can you please bring it over, back over to the side where it belongs?
Carl,
I have a question.
Sure.
I was going to ask, are you going to make that one-page lawsuit available also?
Sure. If you guys want it, sure. Just Google, email me. I don't care. It's a public record. It's a PACER, man. But of course, PACER, I'll make it available for everybody.
Gene, wouldn't your position of who you are need to be entered into a case such as this?
Sure. In 2 or 3 sentences. I wonder how I did on mine, man. It's real simple. Let me see what I'm going to the computer. Let me see what I did on mine. But go ahead and you talk to Ben stuff while I look for this thing. If he wants to ask me anything, like you guys want to ask me something, I'll find it.
Well, I think Mel was referring to a declaration of status of sorts that you turn into the court prior to ever answering anything in the court to establish on the record who you are and who you are not. Does that enter into this? I heard you say that you have all of that stated in 1 or 2 sentences on your claim.
Yeah, right, that's what I'm saying. I do it as I'm never a defendant, and I got that from Billy Thornton. You're never a defendant because the best, what does Billy say? If you're a defendant, the best that you could hope for is a draw. You can't ever win anything if you come in as a defendant.
Okay, what if you have already admitted to being a defendant?
If you're already admitted to being a defendant?
Yes, I mean, this is in history now, and the foreclosure is already finished. The summary judgment was given. You have responded as the defendant, and I realize where that takes you.
Well, that wouldn't matter, Gene. What matters is that the attorney filed the summary judgment, and he doesn't have standing. So you do your common law or whatever your format for your void judgment on the grounds that he wasn't the real party of interest. He cannot, as an attorney, file anything in the court. He has no standing. The real party of interest is the only person.
Well, that has been my whole case all the time, that he has no standing. There's no subject matter jurisdiction.
Well, but you're not going to even raise that. You're just going to say that he had no standing because he is not a real party of interest and had no firsthand knowledge of the event.
Right. what's good is what you're saying, Ben. You guys are real smart. I mean, I'm telling you, I swear to God, I'm not fooling around. You guys would make pretty good attorneys. But the whole thing is now, what you just said, write it down. Now, break it down simple. Instead of saying real parties of interest, that's a term of art. It's a term.
Well, I know, but I was using the term to explain the position. I wasn't saying to use that in the substance of your document. I'm just saying that as the description of it.
Right. This is so simple. I made my parties thing. This is a thing of beauty. Is a thing of joy. Claim it. I just wrote parties. Claim it instead of saying I claim it. Just claim it. I, a man, by my will, move this case through this federal court, by way of right, secured and protected to a man by the Bill of Rights of the United States Constitution, Articles 1, 7, 9, and 10, and under the common law of the land. Blackstone's Commentary, 378. There you go. So by me just saying, I, a man, there you go. I established all that Joshua tree, Jesus, I'd say, Bible, blood family tie of whatever. I, a man, that's it. By my will. Only man has a will. Move this case. Only a man can move a case. An attorney can't do it. So there you go. I, a man, by my will, move this case. There you go. That explains volumes of declarations.
That's powerful. Yep.
And then I say through this federal court, all lowercase. Because federal means what? Does anybody remember what it meant? Said federal means Jewish, Hebrew? A pledge. That's all it means in Hebrew. It means the pledge. So we're just pledging that if I'm in Alabama and you're in Mississippi, I know I'm going to lose if I file a lawsuit in Mississippi. You know you're going to lose if we file in Alabama. So we're going to set up a court of like an independent jurisdiction. We're going to call it a federal court. We pledge to meet in this court, and it's going to be fair and impartial. That's all federal court means. So through this federal court, there you go, by way of right. Only man has a right. Government has duties, responsibilities, and obligations. Only man has a right. So by way of right, secured and protected to a man. That's right, because the Constitution was to secure and protect the rights of man. There you go, by the Bill of Rights of the United States Constitution, Articles 1, 7, 9, and 10. There is no such thing as Article 1. There's no such thing as the Amendment. It's idiocracy. The First Amendment was the 11th Amendment. First 10, what you call amendments, are called articles. They're not amendments. So when you know somebody who really knows they're saying articles. When they don't really know that, they're saying a Second Amendment. It's not a Second Amendment.
Well, Karl, give an example of how you would do a void judgment on a summary judgment to a foreclosure.
Well, just like you said, you gave a great example. I said, that's beautiful, what you just did. What you could do is just do what you did, but put what you did, compare that with, and you can put that down in a footnote. And that nice legal thing that you just said to that man, it was beautiful. Not real parties in interest. There was no, there was a ratification of commencement of, all that nonsense. It's beautiful. And I know that's Rule 17. It's beautiful, that stuff you're saying. But if you start speaking legalese, they're going to be able to start speaking legalese. So you have to take all that beautiful legalese that you know and simplify it like I just did. My stuff used to be just as ridiculous as everybody else's stuff. It used to be hundreds of pages long. Now I got it down to 1 or 2 sentences. Because only a man can make a claim. Only a man can move court.
Well, let me ask you this. Could that one-pager that you just did, you were removing a case to a federal court, could a person not do that after a summary judgment, is put that into the court, of the trial court that issues the summary judgment and remove that to a federal court?
Well, keep it in the court where it was. It's easier to keep it right in the court where it was because it's void on its face. You're not saying
Dean, what he was doing was filing an original action in federal court to seek damages that he had already sustained. So he was... Yes, okay.
Gotcha. Okay, I misunderstood that.
Right. Got this lawsuit open. When I got this lawsuit open, I just made it simple. I mean, jurisdiction. 1, the parties are diverse. So everybody knows when the parties are diverse that separate states or separate citizenship. I didn't say that we'd have different citizenships. I just said the parties are diverse. I'm diverse. I'm different than the other guy. There you go. I said number 2, there has to be a matter of controversy between the parties. So I said number 2, there exists a matter in controversy between the parties. And or number 3, the value in controversy exceeds $20. And or number 4, the power of a federal court can provide the restoration of rights. Number 5, I can move a court and order monetary compensation for damages. So that gives me jurisdiction over the other side. That's what we want to establish, jurisdiction. parties are diverse. There's a matter in controversy that still exists between the parties. The value in controversy exceeds $20 or $75,000 or $1 million, whatever you want to say. And the power of the court can provide restoration of rights. And I can move a court and order monetary compensation for damages. So there you go. Here's my jurisdiction.
Okay, now let me again. I hate to keep pounding on this, but you can give a lot of people that's in foreclosure or had a foreclosure a remedy. So I want to keep going back to this. Is there any reason that I could not, or a person could not, start an original action in a federal court like that? Again, you may not want to use the term of art, wrongful foreclosure, but put it in simple terms, and have a judgment made on that they're, exactly what we're talking about, handed down by a federal court, and nullify the whole thing. Because it's a den of thieves in this court. They all are. I realize that, but they all support each other. They all make a little money off of this thing, and I've already seen the judge is out of control, and I'd really love to go to a federal court with this thing. That would be my preference.
Look what I told you when he first started explaining to me. I filed, if you see a civil cover action sheet, form JS 44, I checked box to mark injury, tort claim, and the number was 360. Nice big box, and I circled with a red circle. They moved my claim over to a complaint in a checkbox 440, civil rights complaint. Now, I said, when you want to file on 42/1983, oh, sorry about that, Ben, you were saying that, I kept jumping on you. You can't, you have 4 elements to move a 1983 claim against somebody, but the second element is critical. The act that they did against you, or the inaction they did to you, must be because they discriminated against you, be based upon sex, your gender, sexual orientation, religion, race, or disability. If you don't qualify for one of those, it's a U.S. versus Georgia, 2006. Scalia said it's not a prophylactic remedy for all of mankind's ills, Title 42, 1983. It's a specific protected class of citizens that are only allowed to use that, as a remedy. So I realized that. So I said to them, why did you put me under this protected class of citizens when I clearly do not qualify as one of those protected classes of citizens? I said, well, I didn't know how else to put it into the computer. He told me, this is the federal court. This man's name is William. I recorded every single conversation. I gave it to the U.S. Marshals the other day. I recorded every single thing. I said, you going to have to put it back into the original jurisdiction under a tort claim, under common law, under under section 3, on your cover sheet is 360. Leave it alone. I said, he said, well, I don't know what U.S. code to use. I said, so you use Title 42? That's public welfare clause. I said, I'm not on welfare. I'm not discriminated against for housing or jobs or what? I said, no, if you want to use a title code, use Title 28, Section 1332, diversity of parties. You can do that. I said, leave it alone. Don't put me under Title 42, and he did. So when you say, let's run to the federal court, it's not going to matter. I'm having this nonsense, and I made it so crystal clear, and the lawsuit's so simple. Somehow, they converted a forgery claim into some sort of civil rights complaint, saying I said that my child was kidnapped. I said, I didn't say anything about kidnapping. There's no word kidnapping anywhere. What are you talking about? I said, my claim is so simple, it's freaking scary. I said, it's one sentence. I said, the matter of controversy, forgery, the DHR, which you can call the CPS, the DHR uttered a forged instrument which is interfering with my rights. See Exhibit C. And they looked at Exhibit C, and then they realized, oh, this has to do with the child, and da-da-da-da-da. So they automatically converted my forgery claim into a kidnapping. I said, no, because they uttered a forged instrument, the snowball effect happened. Then it interfered with our rights to visitation. Then it interfered with our rights to custody. Then it wound up being a kidnapping. Then it took an unlawful and forceful detainment. Then it took into a libel and slander. I said, no, those are independent standalone causes of action. But the primary tort claim, the primary trespass, was the utterance of a forged instrument. That's what started this. How did you get it so far down the line that the federal court converted it over to a civil rights complaint and said it was based on kidnapping? I said, this is ridiculous. Because the marshal said to me, He said, well, you're complaining with it, like over custody. He said, custody? The child's back with my family. What are you talking about? He's living with grandma. He's a happy guy. My mom's happy with him. They love each other. What are you talking about? They said, well, they're saying that you're like a crazy dad and you want the custody kid back. The kid is back. What are you talking about? The kid's custody's been back for 5 years. I said, I'm filing damages for them using a forged instrument. They said, me and my wife signed them away to the state that we didn't want them, and it took us 8 years to get the contract. And I showed the federal marshal guys. I said, you see this contract? Read it. He says, it doesn't have your name on it, your wife's name, or your child's name. I said, no, absolutely not. Does it say anything about a hospital in here? No. I said, you see when it was signed? It was signed before he was born. I said, you see what they put in as an exhibit, as the contract? And I said, here, here's from the Attorney General's office. What does this say here? Upon agreement between the parents and the DHR, the child was placed in the Shelter Care Division of Alabama. See Exhibit 41, 42, 43. I said, you see what the number on that page is? That's page 41. It's 42, page 43. He says the mother's signature will be found on the bottom of page 42. What do you see in that signature? Margaret Mangina. Now, does that sound like Mary Lentz? No. He says, do you believe me now? Your contract is a forged instrument? He says, absolutely. He says, now I see what they're doing to you. And the U.S. Marshal said to me, he said, Mr. Lentz, he says, we got agents up a little bit north of you, and Mr. Bauer, he said, I'm going to let them know what's going on. If anybody bothers you where you live, if anybody's giving you a hard time, if we can't get there first, you call him up, and we'll have the marshals come and get you in a heartbeat. They said, we see exactly what the state of Alabama and the federal courts are doing to you. I said, why are they doing it to me? I said, what's the nature of the defendant? He said, the defendant? He says, what are you talking about? I said, the DHR. The CPS. What's the nature of the defendant? And he read it, and he said, the DHR, 1, is a federal agent. 2, is a state agency. 3, was under the control of the United States District Court for Middle Alabama, Northern Division, at the time of the declared tort wrong. I said, yes. I said, they're a federal agent. How are they a federal agent? This is what the U.S. Marshal said. Because they receive federal funds. I said, bingo. And I said, where can I find that? He found it. He said, you found it in the Alabama Code book. I said, bingo. What does it say under Title 38, Section 6.5? It says something about them being a federal agent. I said, bingo. It says, the DHR acts as a federal agent. There you go. So, I'm suing a federal agent in the federal district court. And they were under probation at the time when the crime committed. Who was their probation officer? Ivor Groves of the United States District Court, Middle Alabama, the court that I'm filing a lawsuit in. So why do you think my stuff went from a claim to a complaint? They're covering their own asses. He's like, holy cow, just I see exactly what they're doing now. So we talked about an hour or two, we laughed, Joe. Oh, he laughed about the dollar amount. He pointed to the dollar amount on my lawsuit. He said, did you write that number? I said, what number? That number, $365,665. I said, he said, what is that? I said, I talked to the Department of Justice, Sandy Callahan, the chief criminal prosecutor for the Northern Division of Alabama. And he told my whole family, you better put a whopper of a number down in your lawsuit. Nobody's going to care. I said, what do you mean by a whopper? He said, a big one. I said, so ask him. I said, he's a lieutenant colonel for the Army Reserves. I said, ask Sandy. I said, I thought he really embarrassed me like years ago. He said, somebody's going to have to learn the law in your family because I'm telling you, you're not going to get a lawyer to help you. And he said, and you better learn. And he says, who's going to learn the law? So my family's lazy. And I said, okay, I will. And then he said, you better learn how to be a man. So I thought he was insulting me because I'm a big guy. And I said, what do you mean a man? I said, yeah, I took him. He said, no, you know how to be a man in court. You might know how to be a man, but you know how to be a man in court. I was so pissed that I said that to the marshal guys. I did the old, wait. I said this to the marshal guys. I was kind of upset with the guy calling me not manly, I thought he was saying. I said, about 14 months ago, I learned what a man and standing as a man in court meant. I said to the marshal, I said, do you all this paper on the desk that I spread out for you? I said, this is all bullshit. When you know how to stand in court as a man, I don't need a single fucking piece of paper anymore. I could do this all on my own in 2 sentences or less. I said, but I used to have to do all. I said, believe me, I'm guilty as any free man in Montana, making hundreds of pages of lawsuits. I said, I was just as stupid as those clowns were. I said, believe me, trust me. Sandy Callahan was right. Once I know how to stand in a man of court, I don't need a damn piece of paper. He says, all to be done in 1 or 2 sentences. I said, it was brilliant. I said, I'm glad he didn't teach me the trick 8 years ago. I said, because what a hell of a journey I've been on. What an experience of learning all this stuff. So I know all this administrative bullshit. I know all these legal words, just like you do, Ben. You speak it really good. So this is a hell of a trip you're going to be on. But when you really do realize how simple this is, you're going to be like, holy, this was ridiculous, all this nonsense I did. I wrote a law dictionary, encyclopedia. I went to Georgia. I live right down the street from Washington Lee Law Library. I spent 2 years in that library. I wrote a freaking book just on legal terms. I don't need any of them anymore. This is ridiculous. Just go in court and say you're a man, and just make sure the judge realizes that you're a man. You do it in writing first, just like I did very simply. I moved court as a man, by my will, by rights, protecting and secure to me to the United States Constitution, Article 7, 9, and 10. So when you hear people saying Article 10, it's kind of a dangerous article when you hear these patriots screaming, oh, Article 10th Amendment, 10th Amendment. That means that the states have the powers reserved to them. You don't want power. The only time you want power, because power means the right to control another person or another person's acts or inacts. Power means to control somebody else. I don't want power to control anybody. The only time I want to control power over somebody is when they're standing on my feet or trespassing upon me. I want to have the power to pick them up and throw them off me. That's the only time I want power, and that's the only time I want power to have somebody have power over me, is when I'm causing somebody a harm. I don't want nobody to have any power over me other than if I'm harming them. If I'm not harming you, you leave me alone. So when you hear these people say, well, the power is to go back to the states, baloney. They're just as corrupt and rotten as the United States government is. I don't want nobody to tell me what to do or have any power over my body unless I'm causing somebody else a direct harm. So that's the 10th Amendment. And the 9th Amendment just means every law I want to use is my benefit. I could bring any law I choose into court, whether it's the Code of Hammurabi or Sharia law or Catholic law, and all I'm doing is trying to move the court under my beliefs. Now, the trick is for me to convince the jury that my nonsense, my law, my beliefs have any credibility. The jury will say, this guy's bananas. He's using Sharia law. You can't use Sharia law here, Carl. This is America. Go back to Saudi Arabia. Well, you can't smoke peyote here, Carl. If you want to smoke peyote, you go to the Peyote Nation and do it over there. You ain't doing it here. Just because it's my belief and it's my law doesn't mean that the jury's going to agree with me. So, like I said, when you use the 9th Amendment, all the 9th Amendment is saying, gives you the right to bring any law into court, which means any contract that you write between your friends, yourselves, and even though there's not a statute that says that gives you the right to do that, well, you know what? I still have the right to move the court to this district court and have a jury convene to settle my matters civilly with my neighbors, my friends, or my relatives, or whoever, without drawing blood or pistols at dawn. That's why these courts were established by our great-grandfathers, so we could settle matters civilly, and we weren't bashing each other's heads on the side of the street for $5. So that's the 9th Amendment. And the 7th Amendment, you guys know it well. This older man who just said something, not Ben, you know it well. Did you know that it says any suits at the common law where the controversy exceeds more than $20, man has the right to move a court of record, and once the matter is tried before a court of record, no U.S. court may rehear the matter except under the rules of the common law. And there you go. And there are rules of common law for appeal. It's like if the Hatfield and McCoys have a problem, and you wind up in McCoy County, and the McCoys find you guilty, you still have the right to appeal under common law. Say, look, get me to another court, another jurisdiction where it's an impartial jury. I was a Hatfield standing in front of McCoy, so of course I'm going to lose. Even though we had a common law, the trial by jury with the matter exceeding more than $20, do you have the right to appeal by common law? Yeah, you sure do. But is it like through administrative appeals, like take it to the court of... No, you don't take it to a court of appeals. You just take it before another jury. You say, okay, I had to say whatever I had to say to get out of that McCoy County because they were going to hang me. So, yeah, I had a trial by jury, but it was silly. It was all McCoys. So then you could make an appeal that I had the right to try it again. And then, like I said, that's the only way I can see that you can appeal a common law hearing, a common law trial. Sorry about that. Hearings of the civil and administrative courts and trials of common law. But, yeah, I don't want to take over Ben's show, Ben. You got something to ask me or something, man? Ben, you want to ask me something? Does anybody want to ask me anything? Or does Ben want to take over again? Or
Basically, all I was trying to do is get the information out there so people can get an understanding of some of the foundation that this stuff is based on. So that's all this call was really, I think that's all this call was really about.
okay, you did. you said three things before, and I started to jump on you a little bit. Be careful of the 1983. What's the other two remedies you gave people?
Oh, I said a claim for damages on the bond, a direct claim for damages on the bond.
Right.
You can file a civil right 1983 Title 42 lawsuit. You could do a what were the other ones? A tort claim.
Okay.
I know there's another one.
But like I said, I'm typing in the Curse Jurisdiction book. It's volume 67. I'm putting that in right now, and it's section 60 and 61. That's when you're going for the public offices or public employees. I typed it in that little thing for you guys. That's when you're going for first you got to go. I showed the U.S. Marshals. I showed them a whole game plan. I showed them a little schematic game plan. I said, look, I'm on step 2. I got like 8 more steps to do before I'm going to get this judgment. I know they're not going to give me an easy judgment. I know I'm going to have to go through all this nonsense. I said, so they're going to deny sending me back my judgment in 72 hours. Like I'm going to demand and wish. They're going to deny. So what I'm going to have to do is on the Curse Jurisdiction section 60, I'm going to ask for their public oaths of office that are on file. And I said, and because, like I said, I'm trying to remember the case in 1985. Some man took the IRS to court and demanded that they show their public bonds and their public offices and all other stuff. And the court came back and ruled that the Treasury Department is not a public offices. They don't have bonds, and that they're like contractors or employees. So when you try to demand, like the IRS or the Treasury Department, I want your public bond, I want you, and they're only called public offices and public employees, and don't use any of that silly hazard bond nonsense. I think some clown attorney put that down to confuse people like us, because a hazard bond is for like road construction crews when they're going to use dynamite on the side of the highway, that they're going to post a bond that if the dynamite blows out people's CB radios and telephones, that the people can make a claim on their hazard bond. So it's not hazard bond. All it's called is a public bond. There's no crazy fancy word to it. So it's not a performance bond. It's not a hazard bond. It's just a public bond. So don't use any fancy words, because I used to use the word hazard bond because I heard it from some free man in Montana show, a couple of years ago. So, hazard bond. When I actually researched bonds, I said that's the only definition I can find for the bond.
Oh, I thought it was supposed to be an indemnifying bond.
Yeah, like I said, it's just that simple, man. It's just called a public bond.
Yeah.
It's nothing amazing, and I thought it was. I was always led to believe by these crazy people saying, "You've heard of hazard bonds, right? Have you heard that?" Like people,
yes.
Yeah. And when I studied bonds, I was like, "Holy cow!" Some stupid. I think, like I said, a lot of attorneys just dump this stuff in there. So when we walk in the court, we look like idiots. We look like clowns.
Right.
That we're just using this silly stuff, and that we just look ridiculous. It's like, bond, the filling of an official bond. It's called it. Here you go, section 61. The filing of an official bond is generally a necessary prerequisite to full title to an office. And there you go. And it just says what an official bond is. It says the filing of an official bond is generally regarded as a necessary prerequisite to full title of an office. And it is a condition precedent to the right of the person elected or appointed or inducted into the office, and without such bond, one is not entitled to the office and may not legally hold or discharge any of its functions. So there you go.
The bond is basically there to indemnify them, because it's the people, it's the person, it's the man that's stepping into that official capacity that is limited, and if he steps outside of that official capacity, that's why that bond is already sitting there, to indemnify his actions in case he does. Now, one of the scams that they've got going is when you go in and attempt to file a claim for damages on the bond, what risk management will do, and they've done this to some people local here, is actually give the claim form for a claim for damages against the county. So they're trying to convert that damage that was created by that public administrative agency over to the liability of the county, and that's not what you want. You want to stick to the damages on the individual agent. Right. And then the other thing is one of the shams that they pull on trying to get the bond. Now, if you go to your state's government code, it says that the county is required to keep certain books. One of the books in particular is for the oath and bonds to be recorded. And so some friends of mine went to Trinity County Courthouse to get the bond for, we only have 2 judges in our whole county, And the clerk of court, the 2 judges, and of course the county recorder is the ex officio clerk of court. That's in the California Constitution. The clerk of court actually, not only is she the clerk of court, but she is the election commissioner. She is the ex officio clerk of court. She's a registrar of deeds. So that depending on the business that you have to conduct in that office, depends on what hat that they're wearing. Although, you don't physically see them changing hats.
Right.
But,
that's what I'm saying.
And to get their official bond that they take after being elected to the position, what they did was they tricked them, because they also take an oath just to be placed on the ballot, just to be eligible to be placed on the ballot. They take an oath of office. And so that's the oath that they gave people, not the official one that they take after winning the seat. So you got to be careful on what bond or what oath they actually give you. And those oaths also, depending on what office you're looking at, are also recorded at the Secretary of State office.
Right. Well, what I'm saying is, I'm just trying to help you guys. Like I said, I was tricked for many years of being called public performance bonds. I was tricked being called it was hazard bonds. I'm telling you, the only 3 bonds I found in Chorus Juris Secundum, like I said, volume 67, oaths of office, the offices of public employees. The only 3 that I've ever seen written in here are 1, official bonds, 2, fidelity bonds, or 3, indemnity bonds. There's only 3. So don't try to use any other word other than what that clerk of court recognizes, because if you ask for something else, you say, we don't got it, and she's telling you the truth. She knows what you mean. But in law, there's no such thing as a synonym. You better be exactly dead on. Or they're going to say, we can't help you, dismissed, denied. Why? Because you're saying it wrong. So like I said, the only fidelity bond is a fidelity bond of a strictly public officer is a guarantee of his personal honesty of the officer, furnishing indemnity against his negligence or defalcation. So that's all it's saying. It's like if he lies, or if he does something and, which he clearly is not allowed to do, an accident, negligence. So like I said, the only 3 bonds I see in this whole book is official bonds, fidelity bonds, and indemnity bonds. And that's it. Don't use any other word, because if you make a mistake, they'll say, can I see the hazard bonds? The clerk will say, what? Can I see the public hazard bond? What? Can I see the performance bond? What? Can I see the public bond? What? They're just going to look at you like, what? They know what you mean. But they're not going to help you because they're backing up their buddies that they go to lunch with every day. What do you think? They're going to toss you a freebie and feel bad for you? No, you better ask exactly what you ask, and you better wish and demand for exactly what you want. Well, they're totally within the law by saying, that's you. You have no idea what you're talking about. Get out of here. So I was just trying to give you guys a couple of pointers of the exact words to use, so you don't look silly like I'm sure when I said, I want your I didn't know I called them up a couple of years ago, but I want to get your public performance hazard bonds. Like, wow, what a mouthful. None of that creature doesn't exist on this planet. Good luck with that, buddy. So thank God I live right next to a law library, so I could just grab their book and just actually read the exact things I'm going to ask, demand, and wish for. So like I said, first I'm going to go under their public oaths, and then I'm going to say, look, I'm going to go for their oath, their loyalty oath to the Constitution, under Section 60, and under their oath, where it's a qualification of the officer to take an official oath, where it's required, fulfill the investiture of this office. So I said, they're going to squeal up and down, Karl Lentz is a crazy free man in Montana, he's going to take out bonds, he's called paper terrorism, it's disrupting the normal activities of the government.
Okay, KLZ Direct, I forget your first name. This is Mel from Missouri. Would you please quit? There's nobody on here that's a freeman from Montana. Number 1, we may be free men and we may be free women, okay? You're either free or you're a slave. But we're not promoting that club, Freedom Montana. Number 2, all the public officers have insurance, okay? That's easy. Number 3, go to your state whatever and look up. Usually it's in the statutes. And it lists the public officers and employee bonds. None of us talk any of that gibberish that you're speaking on, so it does not apply to this conversation. So, thank you.
I was a freeman style. I lived in one of Schweitzer's brother's houses that he built up here in Virginia. So, no, I was...
Well, we're not promoting the Montana Freeman, or we're not showcasing the Montana Freeman on this call. None of us on this call have any association or affiliation with anyone in that.
I told the marshals I actually believed that stuff. I actually fell for that nonsense. I actually thought that that stuff was the way to go. I said, it's not. All this silly nonsense that going through the county recorder, UCC nonsense, all these site drafts is nonsense. I said, we have all our remedy in the federal court. There's no reason why we can't just use the federal court. The buildings are there, the clerks are there, the judges are there. We just got to hold them to their public oaths and hold them to their bond. Now, all this other nonsense, I said, believe me, I tried all this says the K Trust Act nonsense. I tried all this Freeman and Montana nonsense. It's not going to work. This stuff isn't going to work. I said, I'm guilty of sin of trying all this nonsense in the past. You're absolutely right. I tried everything in the book to try to get my kid back. Because that's my kid. Everything but doing violence. I tried every single trick in the book, and nothing works. I said, the only thing that I see that's going to work is by using the common law, using my rights as a man, and to use the courts that are already established. And hold these judges to their oaths. Because it clearly says on uscourts.gov website, page 1, all federal courts are Article 3 courts under the United States Constitution. There you go.
Very good.
That's how I'm going to do it. So when people say, am I giving legal advice? No, I'm giving lawful advice. I'll give anybody lawful advice morning, noon, and night. Legal advice? No, I don't speak legalese. To me, that's a foreign language. It's gibberish. So I don't make a disclaimer. I say, oh, you want lawful advice? Baby, you got it. Not a problem. Because I'm not stealing somebody's intellectual property. That would be legalese. That's their own special code, their own special language. I cannot use that. I cannot say that. I can't cite their codes. I can't cite the United States Supreme Court cases. That's all copyrighted and trademarked. That's all held by a company in Belgium and Thompson's in Canada. All these codes are codified through a Canadian company called Thompson's. All they did was take public law and codify it and interpret it to what they believe it should read. So when you're reading these codes, Title 18, Title 50, Title whatever you want to read, it's the interpretation of a Canadian company called Thompson's that went down and actually read the public law and codified it. That's all they did. They made a code out of the public law. They twisted it. They manipulated it into a code. That's not public law you're reading. That's code you're reading. And it's a Canadian company. You can't hold them liable. Go ahead and go try to sue them up in Canada for misrepresenting the code or the law. Because you're the one dumb enough to believe in the code. You want to believe in the code? You live by the code, you die by the code. So like I said, and like I said, in public, the state employees are insured. Now,
that's correct.
Public offices are bonded. So do you know where you find where the state employees' insurance is held? Do you know what division of the state you find that in, ma'am?
Well, let's yes, I do. I certainly do. Let's clarify something right here because this gets kind of confusing for some folks. Insurance, all it is insurance, okay? That's what it boils down to, insurance.
What's insurance? Bond or insurance? There's two different things.
Well, when they get a bond, they damn sure have insurance, okay?
Where do you find the insurance to I'm just saying this for everybody in general, not just for your benefit, because if somebody actually wants to file a claim against a state employee for running their car over their toes, you could actually sue them through their insurance division of the state. What state department would you find that under?
Well, you've got the floor. I know where to find it where I'm at.
You're telling me my insurance stuff, my trust stuff is gibberish. So
I didn't say that.
Well, there's a difference between a bond and insurance.
So what is a bond to you?
Ma'am, I know this stuff. Like I said, you're telling me my insurance stuff is nonsense. Now, look, this isn't... I couldn't care less whoever you are. I'm just telling Ben if he'd like...
You didn't say that. You didn't say it was nonsense.
Well, she said the word gibberish in my stuff in the same sentence, so I'll just give you Ben and the other man. If she thinks it's gibberish, it's fine. You're going to find it in the Treasury Division, the Treasury Department of the state, which is controlled by the administrative executive branch of the state. And it's going to be generally called the General Liability Trust Fund. That's the insurance division of the state for state employees, wrongful acts, acts of negligence, or acts of omissions against a person, against your body. So, does that explain insurance? Yeah. Ma'am, this is all I've been doing for 11 years. I do this morning and night. Ma'am, I wrote a dictionary. Nothing I'm saying is gibberish. When I talk to law professors, they can't keep up with it. It's like I banged a pot over their head with a wooden spoon. When I talk to attorneys, you know what the Marshal Service told me? They said, Mr. Lentz, after 5 minutes, you lost us. We can't keep up with you. When I talked to the FBI last year, you know what he said to me? He said to Mr. Lentz, I went to law school. I actually graduated Harvard. After about 10 minutes, you lost me. I can't keep up with you. I said, sir, this is all I do. One Christmas, Tom Murphy called me up on Thanksgiving. I said, wow, it's Thursday already? I thought it was Tuesday. This is all I do. I haven't seen my child in about 3 years. This is all I do. The Marshal Service said, you don't see your child? No, he was right on the street from me. I said, I don't want to break away from doing this law. This is all I do. I said, if I spend 2 minutes playing with them, I'm going to feel guilty, then I'll not finish up the lawsuit. My dad died a couple of months ago. I got to see him, you know. Christmas? What Christmas? What do you know what I did on Christmas Eve? I was talking to Billy Thornton and his crew from London until 1:40 a.m. You know what Billy Thornton and his crew said to me? Because I had to look at the phone after about 2 hours of talking. I said, you folks still out? They said, Mr. Lentz, your stuff is incredible. He said, this is where we see we're not going. Well, we're not finishing it up. I said, right. You're getting stuck trying to get to judgments, aren't you? I said, I'm finishing up for you. They said, this is lovely. I said, the only problem is, I said, when I first got on this call with you folks, it was witty banter going back and forth about the first hour. I said, I've held the ground for 2 hours now. I want somebody to bash my brains in. I want somebody to explain me where I'm wrong. They said, no. The lady from London said, no, lovely, sir, lovely, sir. This is private visit. And the Billy crew was like, this is great.
Does he have regular calls?
Yeah, on a regular call.
No, does Bill Thornton have regular calls?
Well, he had a little personal stuff he had to get. I don't know how well you folks know Billy, so I don't want to get too much into Billy's life if you don't know Billy.
No, I'm saying, does he have open, like a talk show or conference call?
Not lately, because he's had some personal issues going on in his world. Not legal and not health.
No, I'm not asking. I was just wondering if he had an open call that that was archived that people could listen in on, like the one you're mentioning.
Yeah, I'm sure the lady from London recorded it on Christmas Eve. But like I said, Billy's just getting back into the swing of things. He's just starting to feel better about things. Let's just stop there and say he's feeling better.
Sure.
No health problems, though. He's healthy, and he's no legal problems. It's just personal stuff.
Yeah.
So Tom Murphy knows him real well. If you know Tom real well, Tom used to sleep on his sofa sometimes at Billy's house. So Tom Murphy might be a little zingy there, but he's sharp, man. He's a little wacky out there a little bit, but he's a good man. He tries. So when you try to drag him into too much of the old British English common law, he's talking to me too much and saying, keep it simple, Billy. Everything is a trespass. And it could be a trespass on the case. That's what, first, my case is a trespass. It's a forgery. Oh, that's a good example. Use case. Now, trespass on a case is what the federal United States District Court, regular court did. They trespassed on my case. That's my suitcase. I packed that shit. Who the hell was you? Get in there, rearrange it, resort it out, refilize it, and reformat it. That's trespass on a case. Now, I could go up to the court's office for trespass on a case. That's the difference between trespass. Everything is trespass. The trespass covers basically every single one. And then if you want to shrink it down a little bit to make it a little bit easier for the other side to say, you say, well, then you say forgery or all that other stuff that you were saying before. That's fine. But you try to stay out of English common law as much as you can. You try to get everything down to 1 sentence, 2 sentences, and get it done. Just like Dean Clifford said. You know, if you listen to my Dean Clifford show with Angela, everything I was saying to him, he curses like crazy. When I talk to him, he says, oh, lovely, lovely. That's just lovely. You know, he doesn't curse at me. I said, Dean, there's a couple things you're missing. You need to do this, you need to do this, and this. I said, I'm just throwing it out there. I said, you go a long way. Just calm down a little bit. Stop taking the court so damn personal. I said, when I'm in a court against the Attorney General's office, or I'm on a phone call with the governor's office, I said, I'm going at him like an alley cat. I said, but we're in a hallway in the courthouse, me, the judge, and the Attorney General's office. We're laughing our asses off. We go next door, we have barbecue chicken, barbecue ribs. They drink some beers, and I drink some sweet tea. I said, they're like, we can't believe when you see us in court going at each other. I've been to trial 30 times on this thing alone. I know these people so well, it's scary. I said, I'd say to them flat out, you're evil. I said, but you know what? Somebody's got to be evil. I said, somebody's got to be my foil. Somebody's got to be the bad guy. And I said, you know, and we respect each other. And we do business. And when court's over, we laugh and joke. I don't take this personal, and they love it. So, like I said, the U.S. Marshals came because to me, because the district court, the federal district court, was scared. What's this guy going to do? Is he going to go ballistic on us? Is he going to bring militia down here? Is he going to go free man in Montana? What's he going to do? Is he going to go do site drafts? Is he going to take up bonds? What's he going to do? So they said, look, they have concerns. They're trying to figure out who you are. When anybody uses common law, the courts get scared. What are you going to do to them? So I laid it all out. I said, this is what I'm going to do. So the federal marshals were like, well, good luck and God bless, man. He said, you got a hell of a thing going on here. I said, you know, they realized that I'm only not protecting and securing my rights, but I'm protecting and securing their rights. So that's what they told me. I said, how many times can a guy like me go to talk to the U.S. Marshal Service, and the next thing you know, they're telling me, look, if anybody gives you any problems, let me know. And you know what they even told me? They said, any writs that you want to write out for the Marshal Service, if it gets assigned to me, I'll carry it out. He says, you want me to carry out an order through the Marshal Service for you, like a writ of sequestration or a writ of garnishment or a writ of attachment? He says, I'll go get it. I'll go get it for you.
Hey, I got a couple of questions for you.
Sure, go ahead.
This is Dean. This is KMA, the KMA Club. That's what you're on, my call here. So let's get some things out here in the open here. Ben's against the man here. Now, don't you agree that anytime they use color of law against you, the real man, they have violated your rights, not constitutional rights, not all these other rights, but they violated your God-given rights?
No, be careful with that. There's no such thing as a violation of rights. What they do is they interfere with your rights. There you go. That's the word. I'm just trying to help you with that. So do I believe they interfere with my rights? Absolutely. Violating my rights? No. See, so I like to make sure that it's specific, that we say things correctly to each other, so I don't agree with you on violation, but if you said, did they interfere with my rights? Bingo. If they violated my rights, I'm going to have to correct you. I don't mean correct you to sound like a nappy pants and a mammy boy and just everyone I want.
Wait. Let's get something straight here real quick.
Uh-huh.
If you take a word and you twist it around, because I am in there as me. I don't do this for a living. And you're the lawyer, or you're the attorney, or you're the judge or the prosecutor. And you take a pamby word and you twist it around, you just violated it again right on top of that. So if you take a word that I say and you twist it around and you say, well, you lose because you used this word.
That's right.
You lose because you said you were driving, and to win that case, you would have had to said you were traveling, but you said you were driving, so that puts you under our spell. That's bullshit.
The problem is that you even spoke one word to that man in the black robe. What you were supposed to do is do, like I said, all you do is put it in writing. So what is the nature and person the court seeks? And then even if you get past that point, say you can't understand at that point this shit, that's fine. All you have to do to the court is say, I'd love to enter a plea. Who is the man who's got a claim who would like to verify a claim in open court? Is there a man present who's got a claim? May I have the claim? I'd make poor Gordon Hall curse at me like a drunk sailor on his show. And his guest tries to calm Gordon down. He says, I think Mr. Lentz is just saying, when you go before a judge, whether it's a traffic ticket or anything else, you say, is there a verified claim before the court? May I see the verified claim? Oh, there's no verified claim? Is there a man who's making a claim in open court, like viva voce, by his mouth? Is there a man going to testify in open court to a claim?
Do you understand what I'm saying? Do you understand what I'm saying, though?
Right, but what I'm saying is, when you say...
Anytime they do something that works under conspiracy, on purpose, act of willful, or whatever they're doing, that is going against your rights, and depriving you of basically justice in any way, that is a conspiracy. They are, whether the judge is in on it or the judge is not, whether the prosecutor is in on it or he's not, or whatever the case is. Anytime they use color of law is not against the man. Color of law is against them. Okay? They can use that against each other all day long, but once they bring that up against man, that automatically and mandatorily and voluntarily makes that judge have to step down.
Well, what that does,
it disqualifies him.
They could do it to you all day long if you fail to object.
No, I disagree. They can't. Yeah, you're right. They can do it. I mean, you can go and slap the dog crap out of somebody, as long as they don't try to stop you, or as long as they don't turn you in for assault. But the thing is, now anytime you can go back and say, I've got my nerve up now, and that man slapped the dog crap out of me, and I want him arrested. I want him punished for the crimes that he committed, and I want restitution for what he's done.
Right. What you could do is you could just freeze up in court and be scared shitless. That's fine, and you forget to object. You could come back a year, 2 years later, 10 years later, 20 years later, and say, "Holy Jesus, I let that man interfere with my rights." And you could go back and have them restored. That's what it's called, the restoration of rights. You could go back and have your rights restored at any time.
Yep. Okay. I agree with that. Now, here's what I'm just trying to say. Here's another thing. They're always saying, you got to do this within 3 days. You got to do this within 10 days. You got to do this within, that I think that's why we got non-pro talk out there. We can put it back in there as it was as the day it was supposed to be put in there. No problem, because if you didn't know to do it, and they did something, and what they did stole something from you. Now if there was a judgment that allowed them to do that, that is a void judgment, and there is no time on void judgment. I don't care what the judgment was. If it was not a true, honest, and lawful judgment, that judgment can be overturned with void judgment, because they have gone against your rights. They have gone against the lawful, what the court was supposed to stand for. And here's the other thing. I've been looking for the case. There is a case that says that it is the court's job to make sure you don't get screwed over in court. So that means if the judge allows this to happen to you, now he's liable.
Okay. The one thing was administration of your property without rights. That's where you're going for the void. And the other one is Plotsky versus CIA 1987. So that's the two things that you were thinking of.
Okay, what was that?
It's the court's duty to instruct you how to move your claim through the court if you're doing it in error. That's Plotsky versus CIA 1987. And the other thing, when you want to do a void judgment, that will win all the time, is saying that they administrated my property without rights. And what's your property? Your property is your rights. You have rights. Those are your inherent property. So they're administrating your property without rights. They interfered with the administration of your property. They can't do that. So that's why you go back and get a void judgment at any time. You show that your rights were interfered with. That you had the right to exercise your left arm. You had the right to exercise your right to speech. You had your right to exercise the bare arm. You had the right to exercise your right leg. And they interfered with that.
Now, I got some big questions here for you now. We're going to pull out the big guns here.
All right.
I have had, and we have friends that are people that we know that have been working with us and helping us out on this how to win this stuff in court thing. They're in jail. And they're in jail unlawfully. Now, have you got a way to get them out? Now, what's his name? Winston Shroud, he's got a what's that thing called? A habeas corpus. They get not just him, everybody out of jail that's going to court that day.
The only thing you got to do is get it back on the right side of the court. Like I said to Ben earlier, Google will work. Ben hopefully will work real close with you. Ben is going to really study that phrase, the wrong side of the court. Ben's going to study real closely an order of consuance. So he's going to make a claim for consuance. He's going to get it back on the right side of the court, and he's going to say that the judgment was passed in error because it was filed on it was judged on the wrong side of the court, and that you want to move it over to a common law court of record, and you want the verdict handed down from the jury. There you go. You have the right to have every case brought before a trial by jury, and then you can use the Bill of Rights of the United States Constitution, Article 6. It was criminal. It was civil. I don't know how you got in jail on the civil side, but It could probably. I can't imagine how. Because administrative is not like criminal law, but I'm sure they do it.
Well, yeah, every time they bring you up on, what is it, that's the thing they get you for all time.
Not me, man. But go ahead, give me his man.
I'm trying to think what it's called. First thing a judge wants to do, anytime you say something he don't like, he wants to get you for contempt of court.
Of course they can, because you are a contempt of court if you're coming in as a defendant. Now, if you're moving under somebody else's case number, under somebody else's case, you can't speak. You have to move by their rules. So like I said, if I'm making a case against you, bringing Sharia law against you, maybe the Sharia law rules is that, Mr. K, what's your name, sir?
I'm Dean.
Okay, Dean. Mr. Dean isn't allowed to speak. So as soon as you break the rules of Sharia law, and I'm moving the court under Sharia law rules, the dean's not allowed to speak. So you speak, you're going to be held in contempt of court. So if you don't know the rules of the court in which they're dragging you into, well then stop and make your own court. File your own case with your own claim and say, I'm establishing these rules. And that was from Billy Thornton. Billy Thornton, you watched his videos a million times, and he'll tell you, establish your own rules and make not a counterclaim, make your own case. Don't use counterclaims, don't make counter case. You don't want anything to touch their case. You don't want to you don't want to touch your case to even remotely resemble their nonsense, because they're all the way over on the civil side. You don't want to be a counterclaim or a counter case or a cross claim. You don't want none of that nonsense. See, Billy says counter. No, you don't. Don't make a counterclaim. No. You make your own standalone case. You pack your suitcase over here, and they have their suitcase packed with all kinds of bullshit over there. You don't want to match the pieces. You don't want to say, well, let's take a little of this. No. I'm making my case that they're interfering with my rights and they're trying to administrate my property without rights. That's like, say, foreclosure or assessment of property taxes. They're saying they're administrating my property without rights. They're trying to take something out of my pocket. And they do not have a right. They have duties, obligations, and responsibilities. Only man has rights. So anything a claim against a government entity, a fictional entity, and I say that all these little old ladies who are having all their grandbabies taken by the CPS that said, you just make a claim for administration of property without rights. That stands alone. Because you're claiming that little grandbaby is your property, and nobody else on this planet can claim that grandbaby except for the mother. So nobody in the state is going to be able to come into court under oath of affirmation and testify that they have a superior claim to that right to that child than you.
Well, I don't completely agree with that, because when you have a child, the name, if the daddy is around and he's not a baby daddy and he disappears somewhere.
Yeah. Oh no, I'm saying grandma's call me. Grandma's call me and ask me how do I get my grandbaby back. Only grandmas really care about this kind of stuff. I mean, I've never really had dads call me up and ask me. I'm just saying a lot of grandmas. They got a grandma society in Minnesota. That say, some nice little old lady calls me up all the time. She says there's a lot of grandmas up here that we're trying to get our kids back. So yes, I know what you said. The dad's got the first claim, then the mom's maternal mom, I know, then the dad's maternal mom. Yes, I know, sir. Believe me, I know, thank you. But, yeah. Now tell me, grandmas are calling me up all the time. Moms aren't calling me up. Grandmas are calling me up.
Well, did you get a call from Granny? The lady that's been on Rod Class's call and on, I don't know, on all kinds of calls.
Oh, yeah. I've talked to her plenty of times. And somebody warned me. They said, stop, call, stop. She's asking the same. Oh, Angela told me she should call. She just asked you the same question 3 times, and he answered in 3 different ways. She said, that's enough, call. So I said, oh, okay. I said, the lady wants to talk, let her talk. I said, I don't mind. But it's funny, she asks the same questions all the time on everybody's show. And I listen to the older shows, and I think, oh, yeah, she's right. She does. She keeps asking the same question. It was like a 1099 off form on an IRS claim. I said, yeah. It's a retirement claim? I said, yeah. And I started explaining everything to her. How to deal with the IRS. I said, you're administrating your property without rights. That's all it is. Every single claim.
I think the biggest thing we run into out here, and I run into the thing myself, because I don't know how to do a lot of this stuff.
It's simple.
People say to you, oh, you ought to do this, you ought to do that, you ought to do this. Okay, how do you do the paperwork for it? I mean, I can spout a lot of this stuff, but how to put it on paperwork, that's a different story.
I'll send it. If you guys email, I'll send you that 6 little line thing that I give every grandma who wants their grandbaby back. And these little ladies, one lady said, "Oh, I could dance with joy. That is so simple. I spent like $40,000 on an attorney." I said, "Ma'am, you could fly this through court so fast, it's scary. Just pay the filing fee and get on with your life." Yeah. You don't file family court. That's an administrative court. Because that's the biggest mistake these little ladies do. They try to move a family court. So you can't move a family court. It's an administrative court. So what you stylize your claim as the administration of property. See, they're trying to administrate your property because they're administrators. They're on the administrative side of the court. They're trying to administrate. So they're administrating my property without rights. There you go. And Dean used this fancy droid, and I said, "No, Dean, that's some French for administering the property of a dead man through his will, or manipulating a dead man's will." I said, no. Don't use that legalese nonsense, Dean. I said, this is where you guys are going to get caught up. Stop using this. Just say they're administrating my property without right. They got duties, obligations, responsibility. Nowhere in the government constitution does it ever give the administrative branch or executive branch a right. Only man has rights. And you claim your rights. And somebody on the other side is going to have to claim that they have a superior right, and they don't. Governments don't have rights. It's that simple.
Yeah, you got the same thing for a guy that was told you pay this much child support by this much time, or you go to jail, or you can sign over your rights to your child. You got something to think about?
You take him into a court if it's a government official or anybody like that. My mom worked at the IRS almost 30 years. And she told me this secret trick years ago. I said, "Mom, if anybody came forth and demanded that you ordered them to pay a certain amount, could you sign that claim and make them pay it?" She said, "Nope." She said, "Can you even sign your name to it?" She said, "Nope." She said, because I was listening to her on shift back then, and I lived in Vegas a while too. And she said, "Nope." I said, "Why can't you sign when you order that man sitting across from you when you're tax ordering? Why can't you order him to pay it? Why can't you sign the paper?" She said, "Because it's fraud." I said, "What?" She said, "It's fraud." She said, it's flat out fraud. I said, "Then how could you do your job?" She said, "Well, somebody else would do it if I didn't do it." I said, "Mom, come on. Don't give me this good little Nazi nonsense. Why are you doing your job?" She's like, "Well, it pays the bill." I said, "Mom, come on. Why is it good?" She said, "Look, once these people go through the ringer with me, and they actually learn how to stand in court as a man, they'll appreciate what I did." I was like, "No, I think they'll hate you." So she said, "Well, if they learn, through a little of this nonsense that we're doing to them, they're going to learn that we don't have any rights to do any of this stuff to them at all, because all we're doing to them is fraud. And if they know how to challenge us in court, they'll beat us every time, but they don't know how to do it." And my mom taught me how to do it back in 1987.
See, that's just it, though. You should be able to go in there and say, "Judge, everything you're doing here against me is fraud. Everything that this guy or this girl, this prosecutor is doing against me is fraud. And I want all this thrown out, and I want damages." And you should be able to get it. That's it.
You got to do it in writing. You got to do it in writing and say, "Who is making this fraudulent claim against me?" And it's called an interdependent conspiracy. That's when you believe there's more than one person doing it. It's called interdependent conspiracy. That all this nonsense that's going on against your person could only be done by the cooperation of the prosecutor, the clerk of the court, the man in a black robe, the governor. It's an independent conspiracy, interdependent conspiracy.
And and the cop on the street that pulled you over in the first place. Yeah,
it's all in to show that this is an interdependent conspiracy against your rights to travel. That's fine. Interdependent conspiracy against your rights to carry a gun. Interdependent for speech or to redress the government for grievances. That's all.
Karl, run through that traffic case you had going through the stop sign, and how you went into the chambers and dealt with that action, please.
That was funny as hell. So as soon as I got the ticket, it was funny, I have a 69 Camaro, convertible, nice car, but everybody knows it's got a carburetor, it fouls up in the wintertime. So I started the ticket out in the spring around like March 13th. Nice day. I went up about 100 yards down my sister's road. There's only a couple houses on that road. And I started to spit the spot. I said, I better back it up and go back into her house, and I better go clean up the carburetor. So county sheriff deputy was going through the big highway, and he saw me driving backwards. So he flips on his lights, makes a U-turn, and he follows me bumper to bumper all the way back to my sister's house, about 300 yards, about 5-6 houses. I don't know. So I had to go through a stop sign in reverse. I was all over the road, obviously. I'm driving in reverse, and I'm not stopping when he has his lights on. He's on his microphone saying, "No, it's pull over, side of the road." Pull over, pull up. And I'm like, "Yeah, I'll pull over when I get in the driveway." So it's so funny. When I pull over in the driveway, he says, "Do you know who lives here?" I said, "Yeah, my sister." My sister came out. And then he goes to me, says, "You know why I stopped you?" I said, "Product of driving reverse, going through a stop sign and weaving all over the road and failing to stop when emergency lights come on." That pretty well covered. He's like, "Well, yes." He's like, so I said to him, I said, "Well, I started to hit the main highway and the car was spitting and sputtering." My sister said, "What are you doing, Carl?" I said, "What?" She said, "Why are you talking to this man? Just take the damn ticket." I said, "What?" I said, "Oh, I forgot my own medicine." "That's right. I'm sorry, sir. Can I please take the tickets? And can you please write me out the tickets so you can go on your way and I can go on my day too?" So he's like, "Okay." Because I started explaining what I was doing. I said, "Just take the damn tickets. You know how to handle this nonsense." I said, "Oh, thank you." I tried to talk my way out of it. I said, "What am I doing? This is stupid. Just accept every damn thing. This is how we're going to make some money. Go ahead, take it." So I took all the tickets. So then the very next day, that was on Sunday. Monday morning, I went to, I asked the cop, I said, "Are you going to prosecute this?" I asked the county sheriff, I said, deputy, I said, "Are you going to prosecute this?" He says, "No, we have a county prosecutor." I said, "Where is he?" He's in the district court building on the second floor. I said, "Okay." So I wrote my little, "I'm sorry I can't accept such a wonderful present at this time, this wonderful gift." I said, "And I don't have the capacity to perform under these terms and conditions at this time, and I'm going to have to respectfully decline the offer, and I'm going to have to ask you to take this back." So I wrote something nice like that, nice and sweet. So I handed it to they called out the prosecuting attorney Gary, he's a big guy like me. He was a little bit older. His name was like Pigeon or Bird or Dove. His last name was kind of funny. But anyway, he says, "What's this?" I said, "Well, I'm not going to be able to accept these summonses to appear at this time." He said, "Why not?" I said, "Well, I didn't break the law." He said, "What?" And he looks at all these codes. He's like, "Who's the officer?" And I told him. He said, "He's the code enforcement officer for all the new recruits of the county. He's been doing this like 30 years. If he wrote these tickets, you broke the law." I said, "No, I violated code. I didn't interfere with anybody's rights. But did I violate code? Oh, you betcha. I'm sure I violated about a couple of dozen codes on the ride over here today as well." I said, "But I didn't break no law." He says, "Are you a lawyer?" I said, "No, I'm a lawyer's worst nightmare." He says, "Well, I'll see you in court, Mr. Lentz, in 30 days. I said, "Well, I just gave you fair warning that you're going to be committing battery and you're filing a false claim against me and you're going to have malicious prosecution." He says, "Right, fine. I'll see you in 30 days." So in 30 days, I went to district court, and the district court was an old judge on there, great old man. And he does about 100 cases an hour, less than a minute a case. So he makes the county about $30,000-$40,000 in about 3 hours. So they're like the old judge. He only shows up one day a week, makes a ton of money. So I seen the old judge, I was like, "I'm not going to get 2 seconds to talk to this guy." I said, "You know what? You only can win money pursuing them for battery and malicious prosecution on appeal. You first got to be found guilty at the district court level, because you can't go after them for malicious prosecution until you've been maliciously prosecuted." So you go for the easy lose. You don't mind losing at the first level because you can't file a claim for damages for malicious prosecution and battery until you've been found guilty at the first level. That's just the rules. So when I went there, I seen this. He says, the old judge says to me, he says, "What are you here for?" I said, "For driving reverse, failing to stop, going through a stop sign, and weaving, whatever, reckless." He said, "Well, how do you plead?" I said, "I don't plead." I said, "Because first I have to break the law." He said, "What?" I said, "I didn't break the law." So he brought the officer guy to the side. So the officer, like, "Bob, what does this guy do? You want to reverse it?" He says, "Guilty." He says, like, $50 fine this, $50 fine this, da-da-da, fine this, blah, blah, blah. I said, "Is that the final judgment of this court?" He said, "Yes." I said, "Great." I said, "Is the circuit court still open across the street?" I ain't been up in this county in a while. He said, "Yeah." It is across the street. I said, "Good. How fast will the cashier have the final judgment in this court?" She said, "About 15, 20 minutes. I said, "Okay." He said, "You're going to appeal it?" I said, "Oh, yeah, absolutely." So I walked across the street, and I filed for an appeal. It's so funny, when I got there, to the lady, she says, "Okay, it's like of all these fines, it's like $200, and you want a trial by jury? She said, yes, ma'am. She said, okay, I'm going to need like $250, whatever. I said, ma'am, I said, maybe you understand what I'm saying. I'm appealing a judgment. I haven't been found guilty of this thing. I said, I'm appealing a judgment. I said, I haven't, this is an appeal. I said, so she said, you got to pay for the crime first. I said, no, ma'am. I said, let me tell you what. I said, do you accept bonds? And she said, well, yes, we do. I said, okay, watch my mouth. Whatever the jury comes down with the verdict and assesses the damages, I will pay. Okay? And she said, well, that won't work. I said, who's the head clerk here? She said, I am. I said, no. Who's the man's names on that front door? Like Judge, whatever, Judge Schmelz. I said, what's his name? He said, get him down here, and he'll explain to you that when I give you my word as my bond, that's good as gold. So she said, okay, fine. We'll see you in 30 days at 11 o'clock. I said, fine, not a problem, man. So when I went home, I actually took the codes off their website. And if you read their codes, it actually has the law inside of their code. So I went to court, and there was a jury, and the man said to me, it was like 11 o'clock, and 12 o'clock I had this big murder case for like a black guy killing a 7-Eleven clerk. So the courtroom started to pack up. Newspaper people, state troopers, it was starting to fill up. I was like, wow, a lot of people just for my silly traffic ticket. They're like, no, it's a murder case coming up. I said, oh, okay. I said, well, this should take me 5 minutes to do. I said, because I didn't break the law. So it's funny, I gave the prosecutor and the deputy man fair warning. I said, this is your last time, man. I said, you really sure you want to go through with this? I said, I'm going to win. And they said, well, we've never lost. I said, you're going to lose this one. I said, you ain't never been up against me. And they said, well, we're confident that we're going to win. I've been doing this for like 20 years. He's been a deputy for 30 years. We're going to win. I said, okay. So the judge said to me, he said, so you're the one who wanted the jury trial for the tickets, right? I said, yes, sir. And I said, when you pick out the jury members, I said, I just got an easy question for you. I said, first of all, do you like to be called Sir, Your Honor, or Mr. whatever your name is, Schmelz? Which please, I'd like to be called Your Honor. I said, okay, Your Honor. I said, I got one simple, easy question for you. He said, what's that? I said, do you know the difference between legal and lawful? He said, well, absolutely, I'm a judge. I said, okay, well then, I don't need the jury. He's like, why? I said, because I don't dispute any of the facts. The facts are crystal clear. I drove in reverse, I failed to stop, went through a stop sign, and it was all over the road. Those facts stand as true. I'm not disputing them. He says, so then what are you here for? I said, this is a matter of law. I said, so I'm going to let you interpret the law, because I think you're more competent in interpreting law than a jury will. I said, jury, throw the book at me. I said, because they'll feel if I can get away with it, they should be able to get away with it. I said, but you have to stand by the law, right? The black and white law, you got to stand by the law, right? I said, yes, I'll stand by the law. Good. Then I present the law to the court. He said, well, you seem to be going a little bit ahead of us. He said, it seems like you're from New York, whatever. You get a little, how about we slow it down a little bit and we do it our way down here? I said, okay, let's do it your way. How do you want to do it? He said, well, first we introduce each other. I said, oh, here we go. And then he said, well, who are you? I said, my mom called me Karl. You could call me Karl. I said, I'm fine with that. I said, don't call me Mr. Lentz. My dad's not dead, so I don't deserve the title yet. So I said, just call me Karl. Well, everybody calls me Karl. So I said, okay, Karl. Now the other side's going to introduce themselves. 20 minutes later, I'm telling them how wonderful of a sheriff he is. All these badges on his sleeve, and all the years of good service and good conduct and meeting the president for awards. 20 minutes later, this nonsense. We're good to start. So we're 20, 25 minutes into this. I said, look, I can knock this out in 2 minutes. Can I bring the law to the court? He says, no, we're going to do the facts. I said, the facts? I'm not disputing the facts. I did exactly what that man said. He says, well, can he at least take the witness stand and can the prosecutor at least cross-examine him? The prosecutor? I'm the appellant. He's the appellee. I said, you know what? I'm not getting into semantics, who goes first, who goes second. You know what? This should have been over a half an hour ago. Go ahead. You want him to go first? Do you think he's the moving party? You just go right ahead. Let him go first. I don't care. Let him go first. So then he said, fine. So then he put I said to the before he even took this in, I said, hey, does he just have a videotape? Should we just watch this? This whole stop only took like 2 minutes. Let's just watch the damn videotape and let's enter that into the record as absolute proof. I said, you got the videotape on you? Or just give it to the judge. I'll agree to it. He says, no, I forgot to bring the videotape. I said, all right, go ahead. Say it then. Say what happened that day. So the cop took the stand and the prosecutor said, okay, explain what happened that day. He's like, well, on March 13th, on a crystal clear day, 2008, on a clear line of sight, on 1437 hours, on Sunday, and I could see in a clear line of sight, and I level line of sight of the vehicle, and the vehicle described as And he said, and I saw him go through the stop sign, and he refused to stop, and I put my bumper on his bump, and I followed him down to residences. He claimed that the resident of the property of his sister. And this guy was good. This guy was good. So, what was funny, they said to me, would you like to cross-examine him? I said, cross-examine that guy? I said, man, I think I speak good. Holy cow, this guy's a master. I said, you see a picture's worth 1,000 words? Nah, I don't believe that. This guy's 1,000 words is a Rembrandt. This guy's worth a master. I love this guy. I said to the prosecutor, do you object to me using his testimony as my testimony and putting it on record as that's the facts of the case? And the judge says, sir, what did you say as a prosecutor? I said, can his testimony be my testimony? He said, what are we doing here if you're not disputing the facts? I said, I never dispute anybody's facts. Everybody's facts are totally true. To them. Not to me, but to them. I never dispute anybody's facts. If they believe that, if they believe in Santa Claus, God bless them. If they believe in the tooth fairy, who am I to bust their bubble? If that's what they believe is true, I'm not here to convince anything that anybody has to say that it's not true. All I'm here is a matter of law. I did not break the law. So I said to the judge, well, fine, you want that as testimony? Taking his testimony. He says, do you have anything else to say before we wrap this up, Mr. Lentz? He's like, yeah, simple question, Judge. In that whole little diatribe that he said there for another 20 minutes, like, it's 10 minutes to 12 now. I said, did he say anything that sounded like I broke the law? He said, well, absolutely. I went, I actually did. I went, I said, you don't know the difference between legal and lawful, and you told me you did. He said, well, yes, I do. I said, oh, no, you don't. I said, no, officer, you just stay running that stand right there real quick. Let's go let's try this again, and let's see if the judge picks up on this. I said, let me ask you a simple question, Mr. Officer. Did you see some little old lady driving a car coming up the road behind me? He's like, well, no. I said, did you see an old man walking his dog? He said, well, no. Did you see some, little kid riding their pony across the street? He's like, well, no. I said, did you see a cat, a squirrel, a chicken, a frog, a flea, an ant, a fly on the road? He's like, well, no. I said, so you're basically saying you didn't see any of God's creatures, great or small, in my travel path, which I directed that car? He's like, well, no. I said, good. I said, now, when I was traveling in reverse and going through stop signs and reckless and everything else and failing to stop on a cop's emergency signal, I said, did I run over a tree or a telephone pole or a lamp or a mailbox or grass or a hedge or a shrub? Did I do any damage to any man's property? He's like, well, no. I said, good. I said, did any man come forth and file a claim, verify a claim against damage or loss or harm to a man or to his property? He said, well, no. I said, good. I said, watching this, Judge? Watch this. We're almost done. Watch this. This is really good. That's exactly what I'm saying to the judge. I said, now, that white Camaro that you stopped, yeah, pretty car, right? Pretty car. Do you have a title to that car? He's like, what? You own that car? No. Do you have a vested interest in that car? No. Do you know anybody here in this court today that has a vested interest in that car? He's like, well, no. I said, so there's no matter of a contract that we're discussing, right? That I'm not driving something in a car that I agreed not to with somebody, and that you caught me doing it. I said, well, no, nobody in court can testify to that, no, is there? No DMV, no nothing's going to come forth and testify, are they? Well, no contract on a record in front of this court, is there? No, okay, good. You didn't bring a record, did you? You didn't bring a contract, did you? So there's nothing on the record to be entered into evidence today, is there? So you failed to bring any kind of contract, right? Okay, so good. This has nothing to do with contract, then, does it? So, I said to the judge, now, did I break the law? He says, are you done? I said, yeah, I'm done. So I said, so then he said, well, let's wrap this up. So he said, prosecutor, go ahead and you finish it up. He said, well, this is the most ridiculous legalese nonsense law I've never seen such ridiculous nonsense in my whole life. And it was funny, like I said, there must have been at least 8 state troopers sitting off to my left with their little hats on their laps, sitting up nice and straight, waiting for the next trial. So I'm looking at these guys, and they're like, this guy's a nut. They're looking at me like I'm a nut. So the prosecutor said, this is the most ridiculous nonsense I've ever heard in my life, blah, 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 blah. He says, I moved the maximum amount of the fines and that he pays for a trial by jury, even though he didn't have one. This was a total waste of the taxpayers, blah, blah, blah. So then the judge says, okay. He says, the ruling of the court is that for driving in reverse, it's $50. I said, whoa! That's exactly what I said in court. Whoa! He said, what? It's my turn to talk. I said, no, I'm not done. I know the rules of the court. I said, I get to talk, I got the ground, I'm standing, I'm not fucking giving up ground until I'm complete. You've done what I'm saying. So let me explain one thing real quick to you, sir. The next word out of your mouth better not be guilty, because I know the rules of law in Virginia. I got 2 cracks at this thing, and the number one thing that I'm going to file an appeal, I'm going to win on, is you did not allow me to bring the law into the court. When are you going to allow me to bring the law into the court? He said, what law? I said, your law. What law? Whose law? Your law. What law? This law. And I showed him 4 copies. I said, this is a copy of the crimes that you're charging me with. I said, I just printed it off the website a little while ago, just in case at the stroke of midnight, if they revise the code, which they can revise the code at midnight, and now I'm coming under a whole new jurisdiction, a whole new set of codes, but no, the codes match the claims that man is making, a complaint that this man's making against me. So I'm going to ask me to allow me to present the law to the court, because you wouldn't accept it when I first walked in, and these 2 men won't take the paperwork either. I said, I'm not going to get into semantics, but I know if he handed you paperwork, you would have taken it. When I tried to hand you paperwork, you said, I don't want to see nothing. He says, well, fine. I'll look at it on my computer. I got a laptop up here. I'll just look it off the Virginia website. So do it. You just do that. So he starts reading the code. He said, let's just do the first one. Let's go in reverse. He says it's illegal to drive in the Commonwealth of Virginia in reverse, and it's a $50 fine, and it's 1 point off your license. Second time, it's a $150 fine, and 3 points on your license. Third time is a $500 license. He says, see, so you can't do that. He said, guilty of that. I said, I'm guilty. I'm guilty of a code. I said, now, where's the law? He said, the law? Where's the law? I said, what is the law? I said, what does the law say? And he said to me,
you're breaking up, Carl. We can't hear you.
Yeah, hold on 1 second here. Mel, can you mute everybody else out? That's some feedback.
Yeah.
Can you hear me a little better now?
Now, still got some feedback.
Yeah, just give me a minute.
All righty.
Gene, a minute. Deanna. Okay.
Can you hear me better now?
Yeah, almost. Okay, hold on. Let me unblock Gene.
All righty.
Okay, go.
You sound good now?
Sounds better. Thank you.
Okay, so all I said to the judge, I said, read the law now. Go to the end notes. I said, just go to the back where it says end notes. Just click on it, and it'll take you to the back on the end notes. Now, read the end note onto the record in open court for us. I said, you could do it. So he says, it's lawful to drive in the Commonwealth in reverse if, and I swear to God, the judge went, la 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 la, la 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 la, huh, la 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 la, case dismissed. I said, no, not dismissed, discharged. I said, but if you want to hold it as a security instrument in which you could collateralize it and sell it as a derivative to try to make an income for this county, you're more than welcome to do it for the next 7 years. But I better not see that come back up against me. I said, if I do, I'm going to come back and get you for battery and malicious prosecution. Right now, I got a bigger lawsuit I'm working on. I got time for this Mickey Mouse nonsense. So I looked at the state troopers. I said, God bless you all. I said, look, you seen what you just seen today? Pretty crazy, right? I said, God bless you all. I said, my truck was burning. You'd be the first guys to run in and pull me out. I said, but you have to know, everything that you're doing on that highway is illegal. It's legal, but it's not lawful. So you're always breaking the law when you're interfering with man's rights to travel. When he doesn't hurt any of God's creatures, great or small, there's no claim made against the man, and there's no breach of a contract. I said, what you're doing is legal, but it's not lawful. That's the difference between legal and lawful. So what the judge read was it's lawful to drive in the Commonwealth in reverse if you don't interfere with anybody else's rights to travel, you cause no harm to any man or any creature, and that and you're not in violation of any contract. You're not breaching a contract. I said, I just read your law to you. I said, I did it about 12 times to this cop. So like I said, I didn't explain any more to the judge. I said, have a nice day. I'm out of here. You got bigger things to do today, too. You got a murder case coming up. I'm out of here. So the cop ran out. The sheriff's deputy ran out. And he says, oh, my God, what did you do? How did you beat me? I've never lost. I said, I used your own law. Your law. I said, this word for word. What I said to you on the witness stand, is basically just a long version of your law. I said, it's simple. All the laws have, your legal codes always have a lawful way to doing things. Sometimes you have to speed because your child's, a child's bleeding or your wife's pregnant. Sometimes you have to drive in reverse because you're up on a mountain and the road is too small. Somebody's got to go back down a mountain. You can't go back up a mountain, but you can go back down a mountain. I've done it many times, so don't tell me I can't drive in reverse. Don't tell me I can't go through a stop sign. If a car was coming up behind me doing 90 miles an hour, I'm going to go through the stop sign and make a right-hand turn and get out of the guy's way. Don't tell me I can't do these things. I said, they're all advisory. Speeding, reckless, it's all advisory. I said, oh, while we're here, let me give you notice. I said, if I ever come back up through this county again and you see me doing 90 miles an hour in my car, no, not 90. Let's make this crazy. 900 miles an hour, and I'm doing it on my roof, and I'm doing backwards, and I'm doing zigzags all over the road, and do not interfere with my right to travel. I said, I'm going to get you on your official and your individual capacity. I'm going to sue you. And I'm going to sue this county for failing to monitor, train, and discipline you. And because you're interfering with my right to travel. I said, if you don't think I could do it, did you think I could beat you in court today? He's like, well, I said, you want to try to stop me again? And I said, you can warn all the other officers. If you see that white Camaro come through, you just leave me alone. I said, I'm giving you fair warning. So I said, but right now I got a much bigger case that I'm working on right now, and I got time for this Mickey Mouse stuff. And like I said, that's how you deal with them in court. You get them pinned. I trick them into saying, so we're here to discuss that I broke the law. And as soon as they say yes, we're here to discuss the matter that you broke the law. Oh, I was like, oh, wonderful. I got them in their own legalese trick. And I'm not just saying we're here to discuss that I violated a code. I said that we're here to discuss the matter if I broke the law. And they said, yes, we're here to discuss the fact that you broke the law. I said, good, we're not here to see it. I don't throw the disclaimer in there. I said, well, good, we're not here to discuss the violation of a code, right? I see, I don't bother yelling that. Because in a code book, it said what was lawful to do. It said what was legal and illegal to do, and it said what was lawful and unlawful. So I tricked them into getting them to read their own damn code book where it said it was lawful for me to do it. I said, no, sir. If you want to rewind the tape, you'll hear where I said we're here to discuss the matter of law and whether or not I broke the law. So did I break the law? And it was so funny, like I said, how the judge went blah, 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 and when he got to it's lawful to drive in a Commonwealth and reverse it, blah, 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 blah. Case dismissed. I said, yeah. So the judge must have said to himself, holy cow, how many people have convicted over all these years? And all he wanted to do was show me this little end note that clearly says that it's lawful to speed, it's lawful to go in reverse, it's lawful to do this, as long as there's no harm to anybody while you're doing it. It's all advisory. So it's like, holy cow, this man was right. He didn't break the law. So see, that's what I'm saying. So whenever you have to deal with these people, now, if I want to go back and sue them, I can sue them. 5 years have passed. Can I still sue them? Oh, you betcha. Because they interfere in my rights and they filed a false claim against me. And like I said, if you go through the Judiciary Act of 1793, Clause 31, it clearly says that a man has a right to have compensation and restoration of his property or his rights for all time. And if he fails to do it in his lifetime, his descendants can take care of it. His children's children can make a claim for the restoration of his property and his rights. It's that simple. So like I said, you just look in the Judiciary Act 1793, Clause 31, and that's what it says. So that's how I dealt with the traffic court. So that's how big you deal with it. You just trick them into saying, I know the law. So it's always a sweet trick. You didn't say anything about violation of a code, because you're damn right I did it. I said I'm going to probably do it about 50 more times on our way home today. I said, but you're not going to be able to get me for breaking the law. And I'm always going to trip them up by just saying, did I break the law? And the judge is always going to say, yes. Oh, good. Good. Now we're good to go. I tricked you. It's like being a lawyer. It's like being like, hey, that was sneaky, Mr. Lentz. You know what you did. Yeah, I know what I did, and you know what I did. But you don't have no jurisdiction over me, over the law. We're here to discuss the law, not a code. So that's how you trick them. You trick them into the common law side. But that's how I tactfully got them over to the common law side, because it's written in your own damn book. So you trick them over to the common law side. I could have said, oh, this is a common law jurisdiction, and I'm a man, and I got rights, and this is going to be held under the Constitution, the Bill of Rights, Article, and I got the inherent rights given by my God, and natural, and Ezekiel and Isaiah, and I'm the second brother of Jesus Christ and Almighty Sense. Now, I'm not that nonsense.
Could I ask a question on that?
Yes.
It isn't, but what you use there is fine, and I totally understand what you're talking about.
Right.
But what Ben was talking about was actually going back to the legislative act that created the act, the Transportation Act, or I kind of forget, Ben,
It was the Highway Carriers Act and the Highway Licensing Act that actually lists 5 entities that are not required to be licensed.
Yeah, I mean, it's fun. You could go that path with them, but like I said, there's only a couple people on the phone, so I'll talk to you really easy about that. Acts are just acts of Congress. Honestly, most people don't know. Does anybody know? So maybe somebody help me here, because I know what it is. Once an act is signed into law, what is it called?
Statute.
Greg, you can answer, Greg.
Statute.
No, that's 2 more steps down.
Statute at large?
Close. It's called public law.
Public law.
Right. So first, an act. Right. First, a bill is presented to the Congress. The Congress signs it. If enough people sign it, it passes. Then it goes before the executive branch, and the president signs it into law. He vetoes it, or he can ignore it for 6 months, and then it becomes a default law because the president didn't act on it. It becomes law. So then it becomes a public law. So you see public law like 92-154. That means the 92nd seating of Congress, which was probably back in the 1950s, and it was the 154th law passed that year. It gets written on parchment paper, which is sheepskin. It gets rolled up in a tube, and it gets stored in the Library of Congress. So what happens is, after the Codification Act of like 1917, I believe, Congress, some publishing company from Canada called Thompson's goes into the Library of Congress, unrolls the parchment, and codifies it. What they do is they interpret. They make an opinion. It's like finding the Dead Sea Scrolls. They unroll it, and they give the interpretation of what that public law is. They codify it. They make a code out of it. So even though an act of Congress, like whatever you say, Transportation Act, whatever, that is, you don't ever see the actual public law. If you want to go see it, you go to the Library of Congress, and they'll unroll it for you. You can take a look at it, but it's not published anywhere.
What about your state legislators?
I don't know anything about that. I like dealing federal. All I do is federal right now because to me.
But that's what we were talking about earlier. Is I actually have the 1937 general laws. It's the entire act of the legislature that the codes are built off.
You actually got the photograph of the parchment?
No, I have the book that has the act of the legislature. Like right here, it says Act 5129A, Highway Carriers Act. And then it's Statutes of 1935, page 878, amended by statutes, da-da-da. But see, what happened was originally, before they had code books, they would publish the entire act in the general laws. And so that's what this book is the entire act.
Well, what I'm trying to tell you is when they throw the code at you, they're going to throw your code at you, right?
Right, we understand that. We already went through that before you got on the call. We understand that perfectly well. And so what we were talking about earlier before you got on the call was if you were trying to affect the record in a civil action that they brought against you, you could actually get a certified copy of that original act, say this Highway Carriers Act or the Highway Licensing Act, because in that act, it lists 5 entities that are not required to be licensed.
What I'm saying is they're going to drag you into court under some sort of California code, right?
Absolutely, and that's why you would go to the Secretary of State and get a certified copy of the act that the code section is based off of and enter that into the record as an offer of proof if you chose to go that route.
What I'm saying is you just your own case. The easiest way to do it is to say, you bringing me under a code. And you say, yes, well, that's not public law. And you say to the judge, is the law present in court today? And they didn't actually bring the code. They didn't actually bring the law. They brought a code.
Right, Carl, I understand perfectly well what you're saying. What I'm saying is you have options. There are other routes. If people wanted to, and most people do stay in the equity legislative side, there is another way to affect the record, and that is the rules of evidence, the offer of proof rule, that you can get a certified copy of the original act, you enter it into the case file, now it's stamped twice, you got the certification from the Secretary of State, and then you enter it into your case file, then you get a certified copy back out of it, and then you enter it back into the same case file as a rule, offer of proof rule under the rules of evidence. The court has to take mandatory judicial notice. It's a self-authenticating document. In that act, it says that it lists 5 different entities not required to be licensed.
What I'm saying, that sounds great if you have a lot of time to do all this stuff. What I'm saying is this is beyond simple for Joe Schmo normal, because all he has to say when he goes to court is like, where's the law in court? Where's the law before the court today? Like, where's the contract? Because especially if you have a contract dispute with man against man, the contract has to be reviewable for the court. So all you say is, where's the law before the court? And you whip out a code book, you just smile. And you go, oh, that's so adorable. No, where's the public law? And then they'll say, I forgot to bring my copy. Did anybody bring that copy? No, I didn't think so. So since there's no law before the court, I moved the case, have the case dismissed. There is no law in this court today. Have a nice day. So why do all that certification, authentication, when all you say to them is like, hey, did anybody on your side remember to bring the contract? Did anybody on your side remember to bring the law? No, nobody ever asked us to bring the law or the contract before the court, in which is in dispute. Well, then, until you bring it forth, I move to dismiss this case, or discharge this case. And they'll have to let you go. That's exactly what I said to the judge. Where's the law before the court? Here's the law. What law? This law. Whose law? What law? Your law. And you pop the law in their face. Not a code. I popped the law. And so he read the legalese thing. He read the code. I said, now, flip to the back of the book. Read the law. So he read the law. He's like, holy shit. It's like, yeah, holy shit. That's the law. Have a nice day. So like I said, let them do the paperwork. Let them bring the law to court, because they're not going to do it. They're too lazy.
Yeah, but the other side of that is this helps us for an understanding of the foundation of what those code sections were actually based on.
That's fine.
You got to remember, you have had 12 years of study, and a lot of people coming into this have no foundational background. So that's basically what we were talking about before you came on, is where this foundational background came from. And then once you understand that, you can choose the option that you choose to combat whatever action being brought against you.
The only good thing or bad thing about that is, like my friend Greg is on the phone right now too, listening in. He's the man from Chicago. He's a real sharp guy. He does the 4-corner rule. He's started with me with the 4-corner rule, the 8-corner rule. He's the one who really is really good with that stuff. So we talk about that. That's admiralty law. He's really good in. But what I'm saying is, my sister admitted to him. She said when I first got divorced, like in 2005, she said I blasted to the court 2 minutes because I didn't know anything about codifications, law. I didn't know nothing. She said I just said these 3 simple things, the 3 simple sentences my brother told me to say, and I won. So she said that the more and more I started to learn, the more and more I'm starting to lose in court, because I'm thinking I could figure this stuff out. And she says, you know what, it's best sometimes to just say, where's the law before the court? Did anybody bring the law in the court? I said, I don't see the contract. Did anybody on your side bring it? I'm certainly not going to bring it. That's not my job. Did anybody on your side bring it? No. You know what? I moved to dismiss to the law appears. Have a nice day. So sometimes it's best if somebody just wants a quick fix answer, get in and out, and they don't want to study this stuff. That's how I try to help the people. Like little old lady grandmas, that's 30, 60, 70, 80, 90 years old, and they're getting IRS bombarding them. I said, you file a simple 6-sentence thing to the IRS, Department of Treasury. You just say, can you show me where you have the right to administrate my property? Can you show me it? Can you show me this? Can you do this? Is anybody making a claim? Because these ladies are 70, 80 years old, and they just want their retirement. So the ladies just like got a 1040 off form. I said, oh my God, retirement. You must be, she said, they've been taking it, gone my retirement since the last 23 years. I said, oh my God, this lady's like 88. Ma'am, you ain't got much time. Ma'am, just do this. Ma'am, I'll email you the 6 things you sent to the IRS. Just 6 sentences, and you'll be done. File it in your local district court, not in a tax court. File it in your local district court. They got officers that could have to answer no matter where you file it in the IRS. You don't have to send it to a special court. You just send it to the local district court. They know how. It'll work. It'll be okay, ma'am. You know, you send a copy to the Department. I said, ma'am. I said, I'll show you how to send the Department of Justice. I said, just do this, boom, boom, boom. Department of Treasury, and boom, boom, boom. I said, you ain't got a lot of time. And I'm not going to sit here and explain to you all these IRS nonsense and all these thousands of pages that, you know, as freedmen people try to have yourself. No, don't do this UCC nonsense. Just say, you know, where's your delegation of authority? Can somebody put it in writing and sign it? Who's claiming that they have a right to administrate my property? You know, boom, 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 boom. I said, here's 6 simple sentences to send them. And tell them if nobody's making a claim that you demand that you just make a wish and demand to these people, and then you make an order. Because only a man can make an order to the court. Lawyers can only make proposed orders to the court, and then the judge gets to make a ruling whether that order stands or not. You make the order. A man makes an order. I actually got it off the federal website where it said pro se litigants, and I'm not a pro se, but it said pro se litigants, understand this. You better attach your orders to your claims because you will delay your own remedy for 6 months to a year until we read your whole entire case and we determine what you're allowed to have. So you just make the orders, give us the orders, and we'll just sign them, stamp them, and send them back to you. Don't make us guess what you're entitled to. You order us what you want to see on the record.
Right, and I think that's a major flaw a lot of people make. They never put the orders in, never.
Right. The judge is going to do it. The guy in the black robe, he couldn't care less.
Yeah, well, and they usually never set up their pleadings for a motion date either, so they never get heard.
Well, the big thing is you don't really want to plead to a court. You want to always give the court notice. Try to get rid of that word judicial, mandatory judicial notice. Just make a notice. Because once you make a notice, judicial notice is arbitrary. It's discretionary. The judge could or could not determine, make a ruling on it. So you just give the court notice. You're saying, you know, like you're the King of England, you're putting a notice up on the bulletin board, all parties concerned on this matter must appear on this day, or you're going to lose by default. That's your notice. You don't make I used to believe I did the same thing you did, mandatory judicial notice. I got rid of that. All my stuff just says notice. So a king just makes a notice. A king doesn't make a judicial mandatory notice. He just makes a notice to the people of his kingdom. So as long as you do the Billy Thornton method, where you're holding your court, you're the king. You don't have to utter many words. You just say, look, you're a public servant, you do. I speak, you do. I say, you do.
Yeah, but you know, that's easy to say, but Bill, when he's on the talk show calls, he actually admits that the problem is enforcement. He has never broken that side of the action open to where he could force enforcement of his orders.
And that's what I typed that little thing on here for you guys, CJS, volume 73, 60, 61. That's what I was explaining to them on Christmas Eve at 1:40 a.m. I said, this
CJS is now? 73, what did you say?
It's right there in that little, you're on the phone. It's Corpus Juris Secundum, CJS, volume 67, section 60 and 61. Section 60 is their loyalty oath to uphold the Constitution. So if you're demanding that they hold the loyalty oath to the Constitution, that way you get to move under the Bill of Rights. Because I am telling you, these clerks and these judges are incredibly crafty. So they're wearing hats. And when you say to them, are you an Article 3 judge? He'll say yes. But he's not also telling you he's also a tax court judge, a bankruptcy judge, a justice of the peace. He can marry people on his boat. He's not telling you. You just asked him one of the many hats that he's wearing. He's also somebody's son. He's also an uncle. You just asked him if he's an Article 3 judge. He said yes. You didn't trap him and pin him in a box and say, for this matter in front of you today, oh, right. You didn't pin him. You got to pin him.
Right.
This is what I showed the Marshal Service. I'm going to pin these public employees. Now, they're going to, I'm at the Billy Thornton stage. I'm going to demand the judgment. And I said to the Marshal Service, I said, this is sweet. I actually want them to tell me no. Because I'm trying to show a lot of people on these talk show calls, I'm trying to show them the next step. Because if they sign the damn orders and it's done, I'm going to be a little bit pissed because I can't teach you people anything else. It's over for you guys with me. So the next step is hopefully they're going to refuse to answer within 72 hours. So then I'm going to say to them, maybe we're having a miscommunication with the district court. I as a man believe, that I am dealing with public employees. I believe I'm dealing with public employees and public officers. I say you do. For some reason we must have a miscommunication there. Can you please show me, like under course jurisprudence section 60, where it clearly says that upon demand, that the public office's oath of office must appear on file. Can you please put your oath of office on the record? So I can go, this is when I get on pace tomorrow, I'm going to see your public oath on the record. And then I'm going to say, okay, as on public oath that you are bound under the sworn under the Constitution, I am moving you to hold under your oath bound under the Constitution. Now, please send my orders back in the way I ordered and demanded it. So I'm giving you a fair warning. If you do not do it, then you're in violation of your oath. And I'm going to hold you bond for the amount of money that I'm demanding from the wrongdoer, which is $360-something million, or $340 million, whatever it is, some sort of bullshit number. But even the marshal guy laughed at that. He said, what's that crazy number? I said, I'm never going to see a dime of that. I said, but what that represents is 1 second for every, that's $1 for every second my rights were interfered with. So I thought that was pretty funny, and I thought that was pretty cool. So the marshal said, oh, okay, everybody just thought you were crazy that you wrote that. I said, but no, isn't that kind of funny that when I tell that to a jury, the jury's going to laugh? He said, well, he got me laughing. So yeah, he said, we all thought you were Looney Tunes. We couldn't figure where you got that number from. I said, yeah, pretty funny, right? He said, yeah, that's pretty funny. I said, yeah, but it looks pretty horrible, too. Can you imagine somebody interfering with somebody's rights at 300 million seconds? That's kind of crazy. I said, if I get a dime, who cares? I said, I got a beautiful farm. My mom's got a farm. God provides. I don't need your stinking money. I said, if you all disappeared on the planet, I said, I want to find out for a week or two until I come off the mountain. I said, I wouldn't know. I said, I'm living with the Amish and Mennonite up here. I'm doing fine. I said, I don't need you people. I said, but the man told me to put a big number. I said, call up Sandy Callahan. He's the prosecuting attorney for the Department of Justice in Northern Division of Alabama. He told me to put a whopper of a number down there. So I put a whopper of a number down there. I said, do I deserve this much money? I said, please, come on. I said, look at these kids in Oklahoma who got blown up in the nursery. Look at the kids on 9/11 who died. What did their parents get? 10 grand, 20 grand? Please. My kid isn't dead. My kid's fine. If I get any money, great. If I don't, who cares? I said, I'm just showing these people that they can't get away with this. And I said, I'm just showing the Marshal Service, this is my next step. I said, I'm trying to teach a lot of people in this country the very next step because everybody's stuck on this step. So the next step is to go after their oaths of office and make sure that I'm dealing with a public employee and not an agent for the instrumentality known as the United States District Court who works for the person known as United States under Code 28, Section 3002-15. So I'm going to make sure that I'm not dealing with an agent for an instrumentality of the person known as the United States. So that's what I'm going to do next. I'm making sure that I'm dealing with an Article 3 court. I said, it's going to be simple. And then I'm going to go after their bond. I said, so they're going to screen paper terrorism. I said, believe me, you're going to get a phone call from Alabama in about a week. And they're going to screen paper terrorism. He's interfering with the lawful, the process of government. He's interfering with the regulation of government, keeping the regulation of government smooth by paper threats. So this ain't no paper threat. I said, I'm just making them hold under their oaths, and I'm making them perform under their bonds. And if they don't want to perform under their bonds, they got 21 days to answer. And in 21 days, I'm going to keep the bond. I said, their bond is underwritten by the Travelers Group of Hartford, Connecticut. I don't know what the policy number is yet, but believe me, I'll get that too. I said, so right now, I'm doing it the lawful way. I said, I'm getting it off the Marshal site. I'm getting it off the Federal Court site. I'm getting it off of Course Jurisprudence site. I said, I'm getting all this information off of the official government site that you people use in court every day against people like me. I said, boy, it's so much fun to be the victim. It's so much fun to not being on the defendant's side of the seat for once. I said, this feels great. So he said, they're not under any threat under this? I said, nah. So I'm not going to threaten anybody now. I said, I'm winning. I'm the victim. I said, this feels great to be the victim. Finally. I said, I figured this thing out. Take it under the common law side. I said, so all this, I said to the marshals, I said, so all these supervisors that say, oh, if somebody comes in saying common law, send them to Region 9 FEMA camp, if he starts spouting out the Constitution, he's a crazy man. I said, yeah. I said, believe me, I know what your supervisors are telling you. I said, but look, it's on your federal code. It's on your website. It's on a Marshal site. It's on a U.S. court. I said, it's on a federal court website. I said, I'm using all your own rules, how to move a common law court in your rules. Not under some crazy guy from the 1980s, some IRS tax rebel, not some Freeman nonsense. I said, I'm not using any of this nonsense. I said, I'm using your own words against you. I said, it's classic. I said, I'm going to get you guys with your own words. I said, I'm not stupid. I'm not going to use somebody else's words. I'm going to use your words. You see how simple that is? You still there, Ben?
Yeah, I'm listening. I definitely see the potential for sure. Yep.
Yeah, and like I said, because there's only a couple of us left on the phone. There's 1, 2, 3, 4, 5 on the phone. Somebody from South Indiana is on the phone.
Yeah, that was Gene, I believe.
Yeah, but I don't know if he wanted to ask a question now, but he did that story a little while ago, so I don't know how to make him talk or how, if he wants to type.
They'll have to hit *6 because I don't think anybody's actually monitoring the board, and I think if they hit *6, it'll automatically open them up so they can talk.
Alrighty.
Well, I can talk. I've been listening, and my head's kind of full right now anyway. I'm kind of anxious to get my hands on actual paperwork and see samples and things like that so I can, get it in usable form within my head.
Do you see that thing?
All this stuff is posted under his name, Karl Lentz, at My Private Audio under the guest speaker tab.
But I did much better now, man. I made it much simpler for you guys. So here's my email address. I just typed it on that board thing. It's like KL DirecTV 2, only 1 T in DirecTV, not 2 DirecTVs. Just like I used to work for DirecTV. So it's just 1 T in DirecTV, not TTV. It's just CTV. It's just 1 T in TV. And number 2 at gmail.com. I just posted it up there. You guys feel free to ask me a question anytime. It's no big deal. And what I do is I mass email. What I do is I'll block out your name, you block out your email address, who's talking, who's asking me the question, but I mass email it to a couple hundred people, the answer, so I don't have to keep retyping the answer over. If you're interested in it, I'm sure the other 100 or 200 people that I mass email at the same time is also interested.
Well, Karl, I haven't been getting any emails from you for about 3-4 weeks now.
Yeah, because some people were complaining, so I just stopped. I said, you know what?
Oh, okay.
So not you are ungrateful. It's like some people say, stop sending me stuff. It's like, look, dude, the only way I knew your email address is you contacted me. Right? I did. Yeah, right. I never contact anybody. Right. I mean, I tried to ever contact me, never emailed me back. Like the Gordon Hall kind of people or the Winston Shrouds. Nobody ever emailed me back.
Yeah. I have a friend that was just charged with California Government Code 6201 because he was helping some people that was doing a Gordon Hall remedy, and they spent $10,000 worth of their property giving it to Gordon, and I believe he's still in jail. And
that's right.
Was they talked my buddy, before I realized what they were doing, I would have asked him not to do that, but what they did was they had him go into the case file at the clerk's office, and they gave him power of attorney for the guy that was in jail and asked him to endorse 2 of the documents in the case file, and they were suggesting that this would allow them to turn those instruments into a negotiable instrument, and they would be able to release the body. And so Mark did go in there with his so-called power of attorney, pulled that case file in front of the clerk, flipped over 2 of the documents and signed the back of them, and that clerk started yelling at him, you are altering a public record. You can't do that. And he kept saying, no, I'm endorsing the back. Yeah. Well, about 3 weeks later, he's a guy that, he's like a jail preacher and stuff like that, and he's going to visit a different guy at the jail, Trinity County Jail, and they had a warrant for him and arrested him on the spot.
Why didn't he just take the guy for the middle aid for a certified copy, then do that ridiculous endorsement nonsense, and that way if it didn't work, at least he didn't alter an official government document?
Right, I understand what you're saying. Well, my question was after he did this, see, I didn't find out he did it till after the fact, and I said, well, you know what they're going to do, and so I told him they're going to charge you for this, and which they eventually did, and I said, so, of course, those guys had to have foreseen that would be a potential problem. What is your remedy now? And so he called them, and apparently they had none. And so what I'm trying to do is tell him that, number one, 6201 is for, 6200 is for the custodian, like the clerk or some person like that, altered, destroyed, da-da-da-da. 6201 is for a subordinate, because these are all out of the government code. He's not a government employee. There's no complaint.
He is. Once he becomes power of attorney, He is a subordinate officer to that court, and he's bound by the same rules and the same conduct and the same procedures that any other subordinate officer that court has to uphold.
But they didn't file the power of attorney with the court. The guy in jail gave it to him just for him to sign that for him.
When you're pro se, when you move the court in any manner in administrative court, you are subordinate. You have to abide by those rules and play by the same games because you're moving that court. It's like you're obligated, or you're supposed to be aware of the rules.
Well, I think he's got him stumped because, number one, there is no due process because they don't have a complaint. There is no real party of interest. He's not a government employee. And when he brought this up in the last court action and he moved to dismiss, the judge actually got up and left the room.
Yeah, well.
And I said, well, you had him right there. You should have dismissed the action with the clerk and walked out. But he didn't. He waited for the judge to eventually come back, and then they set him up another court date, so he volunteered right back in.
The big thing.
Did you try Form 289091?
The big thing that he should have done, the big thing to me, what he should have done, is just said to the court, I'm here to settle the matter. I've not done anybody any harm or any wrong in the court. I apologize. Now, if there's a verified claim on file, is there a claim pending against me? Is there some man going to come forth and claim that I've caused him harm or damaged his property, or anybody suffering a loss for what I've done?
Right.
Right. That's what he should have said. I apologize because I swear to God, if you say you're sorry, the judge has got to release you. But don't tell many people that, man. And I hope you guys really don't believe that and you really don't do it because that's truly the law of this land. But anyway, just tell the guy to basically just say, if I ever caused anybody harm, I'm sorry that I trespassed upon their rights, but I don't believe I've interfered with anybody's rights. And I'm sorry if you believe that I was acting as an officer of the court, a subordinate of the court, because, in my belief, I was not. See, because if you are pro se, that's why I go bananas when these guys stylized me as a pro se. I said, pro se what? I said, you mean pro se is like short for prosecutor? I'm the prosecutor. They were like, well, no, pro se. I said, what does that mean? They're like, well, something about being an attorney. I said, I'm not an attorney. If I'm an attorney, I can't testify in open court under oath of affirmation. Why would I want to be pro se anything? And they were like, well, that's how they style everybody who's not their own attorney. Or who's their own. I said, I'm not my own attorney. I and my case are now before the court. I and my case are now moving through this court. I and my case is presented to the defendants, to the wrongdoers. If they don't answer me in 21 days, I'm going to get a default judgment. I'm going to get a judgment against these people for failing to answer. If not, they can appeal on the 22nd day and we'll perform before a jury. And the jury will hand down a verdict. And the magistrate guy, he's going to sit off on the side somewhere and he's just going to hand the verdict to the clerk of the court. And it's going to be pressed upon the record. And the order is and the judgment is going to be handed to me. I said, it's going to be simple. I said, I'm not pro se. If I'm pro se, I got to abide by the federal rules of civil procedure, right? And they were like, well, yeah. I said, and where the federal rules of civil procedure come from? And she's like, well, I'm not sure. I said, it comes from the United States Supreme Court. And the court changes, like, more than I change my socks. So they can come up with new rules all the time. They come up with new opinions, new rules all the time. I'm not going to try to study their rules. You're crazy. I'm not going to bound myself to that. If I make one mistake in the rules, you can hold me in contempt of court. I'm not going to bound myself to your crazy rules. I'm going to bring my law into court, which means I establish the rules of my court. If the defendant doesn't like it, he can bring it up with the jury. And he can convince the jury that my rules and my law is ridiculous. And if the jury believes it's ridiculous, that what, you can't give kids peyote, Carl? You can't kill your firstborn. You're nuts. And the jury will throw the fuck at me. But that's my right to bring it before the jury. Don't bound me by your silly rules, and don't tell me I have to know what ratification of commencement of the act means. Don't tell me that I got to understand what 12b6 means. Don't tell me I got to understand any of these rules. I don't have to. The Constitution secures and protects my rights. If I have a claim that's worth more than $20 to invoke a court of record to have a trial by jury against anybody who's done me wrong. And I'm standing to that. Nobody's going to knock me off that standing, that position, that status. You're not going to trick me by saying I'm pro se. Nowhere in the Constitution does the word pro se appear.
Well, and that's another flaw I believe my buddy does, is he, even though I keep telling him not to do it, he keeps putting his all-cap name and saying that he's a representative of the fiction. And I keep telling him not to do that, but he just keeps doing it anyhow.
I'm going to watch Dean Clifford. Dean Clifford is a great example why you should embrace that name. Love your birth certificate, because Dean Clifford is right. Because you know Tom Murphy. Mm-hmm. So he knows people over in China and stuff like that, because he's traveled all over the world. I said, right. There's a wind farm company in China trying to put up a wind farm near Seattle, Washington. But it's too close to a naval base, so they can't get permits to build up the wind farm, even though England's got them, Belgium's got them, Germany's got wind farms over there. The Chinese aren't allowed permits. And I said to Tom, all you have to do is talk to these Chinese people, and they got a big lawsuit against Barack Obama for denying them right to access when England and everybody else can, like discrimination because they're Chinese. I said, what you have to do is just get in touch with them. And those folks out there, the Thornton crowd, actually did what I said. Get in touch with those Chinese folks and tell them that you will obtain the permits for them, because by birthright, by proof of your birth certificate, shows that you have the right to claim the resources of the land. So these are your resources you can claim, and you can only claim them by birthright, and that birth certificate proves beyond a shadow of a doubt you were born upon this land, and you have right to access and claim and mine and do anything you want to the resources upon this land for your survival and your benefit. Only another man can tell you, deny you your rights. No government can say, we got too many wind. No, bullshit. I'm putting mine up. If he can put his up, I can put mine up. Well, CFR regulations, bullshit, CFR. That has to do with administrative policy. The executive branch of government ain't got nothing fucking to do with me.
Right. Hey, when I was talking about that guy's case, I think your buddy was piping in the background, and we can faintly hear him. Could he repeat? He was talking about a form, I believe. He mentioned some numbers.
You want to hear me?
Ray, go ahead.
Yeah, we can just barely hear you.
Okay, well.
Sorry. Oh, there we go.
Go ahead, Greg.
Another alternative to get out of jail is Form 28, 90, and 91. Did you hear that?
Could you repeat that, please? Form 28 and what?
90, 91.
91. Somebody just sent me that 90 and 91. Is that OF 90 and OF 91?
I believe so. Yes.
Well, I downloaded those, and those, when I read those are for a government contractor releasing a surety bond or a bond for a performance bond for a contract from a government contract, and those forms can only be filled out by the contracting officer. I just downloaded those 2 days ago.
Right. And
so how would you apply them to a prisoner, and how could we fill them out if we're not a government contractor?
Did you forget that you were an authorized signatory for the United States of America?
Well, I must have.
Tell us, Greg.
Have you ever looked at your checking account?
I've never had a checking account.
Well, if you take out a checking account, and you'll see that your name in the upper left-hand corner is filled out in all capital letters. You think, oh, well, they're just lazy. Well, I've also had the opportunity to have my own little business for 25 years. And my company is also in all capital letters. And in the old days, underneath my signature line for my business, it had very easy to read authorized representative, and over the signature line. And so, obviously, when I created a company, I understood that it was a fiction. I made it up, and everybody agreed, and it was a franchisee of the government, blah, blah, blah. And so, of course, my company didn't really exist. I really existed, so they needed a flesh and blood man to sign for the check, right?
Right.
So I was the authorized representative. And that makes total sense, because it's a company.
Yes.
Right? And so, okay, that's easy. Now, I started looking at my personal checking account, and there was this little MP for microprint on the signature line.
Yeah, I'm familiar, and it's
and so if you blow it up about 400 times, put it on your scanner and look at it,
it says authorized representative, authorized signature.
Yes.
In this tiny little thing, it's not really aligned.
Right.
And I was starting to think to myself, well, for God's sake, I totally understand why I'm an authorized representative for my made-up company. But why do I have to be an authorized representative for me? You know? And then I figured out, oh, holy cow, you know, that's not me. They created a company called Gregory G. Grayson instead of me. And now I'm signing checks for this other thing.
Right.
And who is this other thing? And so when you do the distillation process of looking into the whole thing, you find out that your all-capital letter name on your checking account is an anagram for the United States. Okay?
Wow.
That all the money you're putting into your personal checking account is going directly into the United States. Directly. And that's why they can take it anytime they want. That's why you can't stop them. Unless you make special deposits as opposed to general deposits. And that's under 12 U.S.C. 411.
Right.
Okay, demanding lawful money and earmarking it as a special deposit as opposed to a general deposit. So the long and the short of it is by default, you are always operating as an agent of the United States. You're always a signatory for the United States. You are always discharging the debt of the United States. And you didn't know that. So, when you fill out these forms, June 28, 1991, you're already operating as an authorized representative, signatory of the United States. Ta-da!
Okay, so now on those forms, they're asking for the surety bond number. So if you got a guy in jail and they're wanting the contract number and the surety bond number, what would you...
I have a complete instruction set on how to use them.
Oh, see, that did not come with the information that I received.
I have a follow the bouncing ball instruction set that I would be happy to send to Karl to tell you.
Oh, please, please, because I'm helping a guy in Arkansas that got convicted of cultivation.
God, that sounds like nature. Anyway.
This is Drew in Mississippi. Can you hear me?
Yes, sir.
This Gene and those of us that have been on this call that came over on the KMA,
yes,
we would also like that because there's several of us that are wanting to help people, and I myself I'm retired military. They've been stealing a third of my retired military pay for about 3 years now. And so I've been trying to figure out how to counter that.
Well, Drew, as soon as I get that information, I will forward it to Gus and Gene, if that's okay.
Yeah, that's fine. And he'll get it to me.
Yes.
Yeah, then Ben, I'm going to send you that little 6-line thing that I sent the little old ladies to deal with the IRS.
Absolutely.
Okay.
And just explain it to these men if you can. You know, you seem to be pretty confident and you understand where I'm coming from. So the big thing, if you guys want to know about why it's a good thing to have a birth certificate and stop these other, there's a lot, 99% of these people on these calls try to get you guys to get out of your birth certificates. No, embrace it. Because that's how you can claim the resources of the land. Nobody else can make it. Somebody's got to prove it. So Dean Clifford explains in great detail that it's not such a horrible thing. Because I used to think it was a horrible thing because everybody on the radio was saying it was a horrible thing. And so Dean explained it in trust law. And it's like, that's how we can show that we're on this side if we want to be on this side and deal with the government. But we don't have, and then like I explained to him, but you could also exercise your left hand when you want to and don't exercise your rights to be a citizen when you don't want to. Because like I said, what happened if, like I said, they say, all Americans, all U.S. citizens come forward. But then when you land and they say, well, all the other U.S. citizens died, how did you make it through? It's like when they said all the U.S. citizens, they recognized, coming forth and At that time, I didn't want to exercise my right as a U.S. citizen because they would have slit my throat and thrown me out of the airplane. The Palestinians killing all the United States people. So when I go to court, sometimes it's a benefit for me to say I'm a U.S. citizen. Like if Gaddafi's holding me kidnapped, I want somebody to come and save me. But at other times, it's going to be a detriment to me to accept the benefit of being a U.S. citizen. I can't accept such a wonderful gift at this time because it's actually going to cause me harm.
Right.
Just like when Abraham Lincoln got those elephants from the Tsar of Russia, he's like, what do I do with elephants? You know, it's a wonderful gift, but I can't accept them because nobody here knows how to take care of an elephant. So it's a wonderful gift, but at this time, it's actually going to cause me harm. I got more than I can handle, and I can't handle 3 more elephants in my backyard. I already got 7, but thank you anyway. I can't accept such. You have the right to exercise it, which means that you have the right to accept it or not accept it if it's going to cause you harm.
Right. The way I look at citizenship and the U.S. person is, I kind of like a purse. I mean, not purse, like a wallet. Like it's a thing. Okay, it's not me. It's the thing that I own, I possess, I control over. It's like the wallet in my pocket. I could lose my wallet and I could lose my person.
You're breaking up and it's hard to hear you. Could I ask you to get a little closer to the phone, or something's wrong, or maybe it's my phone, I don't know.
That's Greg's phone, yeah.
Or, well, maybe it's the Martian.
Oh,
Yeah, no.
It cleared up now.
Yeah, it's better now, Greg.
Okay.
Yeah, you close.
Okay here.
Yeah.
Thank you. Anyway, a U.S., a 14th Amendment U.S. person is something that you possess like a wallet. It's not you. It's something that you can put in your pocket or you can leave at home. It's something that you can take and have a new suit on. It's a thing. It's not you. But it's something that you can use in the public if you decide to use it. Kind of like, oh, should I use my MasterCard or my Visa today? I don't know. Which one do I want to use? Okay? Your MasterCard is used man. Your Visa is your U.S. person. Which one do I want to use? Huh. Okay. Well, maybe I don't want to use that one anymore. The interest rate's really high. So I'm not going to use that one. But it's a thing that you have in your possession. It's like your car. The only difference is you can't sell your U.S. person. You're stuck with it. You can't find somebody else to buy it from you. Right? That's about the only thing. So if everybody just looks at it like that, it's just a thing that they gave you when you were born to stick in your wallet and carry around, and it's not you, but it's a tool.
Yeah, and you know what a great benefit it is for, too? It's like I said, when you file a 1983 complaint like you were saying, Ben, before, it works great if you have a problem with somebody discriminating against you for your gender, your race, your sexual orientation, or that you're handicapped. Now, one day I might be handicapped. I don't think I'll ever qualify for the other forms of discrimination. But if I do, at least I could rely upon the old 14th to make sure that they don't discriminate against me because I'm in a wheelchair. Now, one day I might need to rely upon the 14th Amendment, but at this time, it serves me absolutely no benefit. As a fact, it's causing me harm. So I don't force me to go up this wheelchair ramp right now because it's a waste of my time, and I got to go all the way around the building to use it. I don't need it, but thank you anyway.
Right. So
that's
have either of you actually used this Form 28, 90, and 91 to get somebody released?
I personally have not, but my friends that pass along to me did.
All right. All right.
Yeah.
Well, when I send that email to Karl, I'll put in the subject line, I'll just put the Form 28, 90, 91, if that's okay, Karl?
Yeah, that's fine. And Greg's got a little group that he talks to a lot that, what's that called, Greg? It's like .me from Maine, those guys from Maine.
No, the .me people is something else. They don't do that. This is something else on my people. But this is more my Chicago friends.
Well, that's what I'm saying. See, I met Greg because he interpreted my lawsuit, and he was doing my claim of consequence or something like that. I was thinking, Yeah, he was doing something. He was reinterpreting what I said, and I was like, wow, this guy's good. You know, he's not saying verbatim what I'm saying, word for word. He's taking it in his language and tweaking my words just a little bit. So then I got in touch with him, like after I heard him on this talkshoe thing, and I just tightened it up just a little bit. I said, no, don't change my commas. Leave my semicolons alone. They're perfect. And then Greg's really good with punctuation like that, you know, with colon, semicolon. So he understood where I was coming from, so I didn't have to explain to him for 3 hours why it was...
No, that was, and that whole discussion came in because one of the callers that was asking questions was challenging that.
Oh, yeah, Black said, why did Carl do that? And somebody said, oh, that's because Carl doesn't know how to use commas and semicolons. Believe me, if you know semicolons, instead of making a whole long run-on sentence, read the 14th Amendment. The 14th Amendment uses semicolons like crazy. It's like the 5th clause. I think it's the 5th clause of the 14th Amendment. It just runs semicolon crazy. They just say, like, say you wanted to say, like, the 1983 Act, the Title 42, 1983, protects the persons, colon, and then you just say disabled, colon, semicolon, based upon race, semicolon, disabled persons, semicolon, sexual orientation, semicolon, religious, background. That's what you use semicolons for. So instead of making these
semicolons allow you to have everything that are between them stand alone.
Right.
The list.
So
commas create modifiers and subordinate clauses, so they become interdependent. If you use semicolons, they're not interdependent; they stand alone.
Well, Greg, do you guys have a talkshoe call? Do you have an open call?
Oh, some of my friends do. I kind of like to stay in the background and just kind of like hang out with my
Are you Greg V? Your last name starts with a V?
Oh, no.
Oh, you're not? Oh, okay, you're a different Greg then. Sorry.
Yeah, he's going through my phone to call you. I called you. He called me, and I said to him, "Hang on, Greg. I'm on I'm helping some folks out here on the talkshoe." He's like, "I don't want to talk no talkshoe." I said, "Just hang on, Greg. These guys are okay. They're up close, man. You guys."
I'm a researcher.
All right.
I am what is sometimes called the wind under the sails.
Oh yeah.
I don't go out there and pitch any sales pitches on this stuff. I spend all my time like a bookworm.
Yeah, most of the time.
Yeah, Greg and I beat each other like a piñata. We just bash each other all the time. It's good.
Somebody's got to do it.
Oh yeah, well, that's what I'm saying. That's why I love bashing. I love when you people bash me. Knock me off my belief. Please do it. I know what I already know. Teach me something I don't. Try to trick me and confuse me. I don't care. And
the repetition helps you put it in the line better, helps you prepare, and helps you be able to explain it better.
Right. I get it down to 1 page now. Like I said, I was guilty. I told the marshals. I told Greg that I was guilty of running 100-page lawsuits. Greg finished up the punctuation with me the other day in that 1-page lawsuit.
Yeah, well, that's what my buddy did, Burl. His were always just simple 1-pagers, too.
Yeah, because Greg was showing me, I was using the word verify. I wrote on the top, verified tort claim. And Greg told me, no, it's tort claim, verified. And I was like, what's the difference? And then Greg could explain to you in great detail, so I can't. But it made sense to me that everything just stands alone. When he says it modifies the, what do you say, Greg? It modified the noun?
Right.
Yeah. And I didn't.
Right.
I went to 10th grade. Greg graduated college. I don't know if he got a graduate degree, but I went to 10th grade.
Well, Greg, would that actually harm suit, or is it just a form of grammar? Would that actually have harmed his action? If he would have put verified in front instead of below?
Yeah.
Don't what?
No, I answered yes to the question.
Oh yeah, but I really don't remember why you told me it, but it made sense after I reread the word. I said, okay, that makes more sense. So I said verified tort claim. I wrote forgery, and then he said no. He said right, tort claim, forgery, verified.
Right.
Yeah, just yeah.
because what you're saying is that everything within is, if you leave it all by itself, everything contained is verified.
So
otherwise,
not
you can't verify tort claim because you have other things besides the claim in there.
All right, okay.
Yeah, see, that was great. That's right. That's why he explained it to me that way. I'm glad he said it again because I forgot already.
Because otherwise, just the claim is verified and not the background information contained within the document.
Signatures or the
In
right.
other words, you want to say the entire document is verified, and so by putting the word verified on its own line, you're saying that all contained therein is verified.
Right, yeah, that makes sense.
Yeah, just that kind of stuff I missed in elementary school. You know, I slept through that part.
Well, I'm even worse. I'm about a 7th grade dropout. I had a hell of a time in school, and I actually think that kind of helps me now because I suffer a lot of that conditioning.
Well, see, that's what Greg says to me, too. We both agree with that, with the little amount of education, formal education I had compared to Greg, because Greg synonyms things like crazy, and I go, oh my God, no. I said, law is black and white. It's very specific. When you say a certain word, do not try to use a synonym to define it. Use the exact word one time, use it throughout the whole damn document. Don't try to use multiple synonyms, just establish. It's like writing a contract. You write that word a million times if you have to. It sounds ridiculous. I can't think of a $2 word instead of this one syllable word. It's like, no, just keep saying man, man, man. Just say I am man, man. Not the Joshua tree, living, breathing soul, entity, of the family of the blood of the,
Right. But I also think that it shouldn't even be a man. It should just be man. I, Greg, man. Not man.
Right, that's fine. But that's what
I think get rid of all the articles.
Right, that's what I mean.
The word the and the word should go away as much as possible.
This is what I was telling you.
It should read like a 3rd grade,
right,
English paper, where it sounds a little bit disjointed because it's not perfect English, but it also gets rid of interpretation. If you say a man, it's like which man? Okay? But if you say man, there's no question of which man. It's really stupid simple, but,
And the worst thing
spot run. See spot run. Not see a spot run.
But that's what I said to people, too. I said, the worst thing you guys can do is get into a definition contest with a man in a black robe. If the guy asks you, well, we're all men here, don't even acknowledge this clown. You do everything in writing. You say, if you have something, Billy Thornton tells you guys that too. Watch the Billy Thornton tapes. You know what I'm saying? Billy Thornton says, oh, that's very interesting. Can you please submit that in the form of a question? I'll get my answer back to the court in 72 hours. Don't answer these guys directly. Just say, oh, you have a question for me, Your Honor? Oh, good. What's the question, sir? And say, court will get back to you in 72 hours. I'll have my answer before this court. Don't answer him right there, because then you lost your status as a king. The king doesn't answer questions. The king demands the audience, and the king demands the performance.
Right.
You don't. Right. So Billy,
it's like if you go out to buy a new car, and the guy's got a really sweet deal for you, and he wants you to commit, and you go, you know what? This sounds really interesting. Let me go talk to my wife, and I'll get back to you. Even if you're not married, you say that. Just so you buy yourself some time to come back with a proper response. So you always cop out to I got to get back to you.
Yeah, because they just lightning through the good business. Yeah, like I said, like Greg will tell you, Carl's style is like one sentence at a time, and he'll like beat that sentence to death. You know, he's not going an inch. He'll take a week to get you to give me that damn answer. I'm not going to give you a second option. I'm not giving you a second question. I'm not giving you a loophole. You're not escaping my question. I'm like a dad, you know, like a good husband say to his wife, I'm boxing in your corner. You're going to give me this damn answer, yes or no. Did you do it or not? Yes or no. I'm not giving you any options. That sounds like a broken record. I'm not letting them wiggle. I'm giving them one-page lawsuit. Did you or did you not do this? And then I'll go on to the next claim. I got 22 independent standalone causes of action I can sue these clowns on. So I'm doing one at a time. I'm not doing first cause of action, second cause of action, third cause of action, fifth. I'm not doing any of that nonsense. I'm doing one cause of action at a time because, like I said, by reading the Judiciary Act of 1793, Clause 31 said not only do I have unlimited time, so does my descendant. Anybody who comes after me could also keep up the claim, even if I drop dead and die. So there you go. I'm in no hurry. I'll do one claim at a time. So that's, like I said, that's how you guys got to, well, to me, I'd recommend stop doing multiple causes of action. Let them deal with one at a time. If they're going to work with you on one, great. If they're not going to even work on you with one, well, then you're wasting your time doing the other 87. Look at the hard time I'm getting for one. They changed my forgery claim to kidnapping under Title 42, 1983. There's no Title 42, 1983 on my paperwork. There's no charge of kidnapping on there. What are people doing to me? So what would have been the point if I put the other 22 causes of action on there when I can't even get a simple forgery claim going through the court?
Right.
Why bother? Just do one at a time and see if you're dealing with a legitimate, honest, good court. If you
Whatever happened with the your filing fee deal, did you just let that go?
Oh, no. The only thing good about the filing fee, believe it or not, is that way you could say that the services. I filed a personal injury tort claim. I paid you $350 for form to do this. Who gave you the right to take my $350? You cashed it to the United States District Court when I clearly wrote the money order out to the Federal District Court, and I got the receipt for it from the Postal Service. I wrote it out to the Federal District Court. Now, who took my Federal Express check and who in the United States Postal Service cashed it? Why did you steal the check that I wrote to the Federal Court? Why did the United States District Court cash it? I didn't write a check out to the United States District Court. I clearly wrote on it in Federal Court. When I said to the Federal Marshals, I said, watch this. When I dial up Alabama, they're going to say, Federal Court, can I help you? And I'm going to say, okay, I want to do business with these people. I said, if they answer the phone, United States District Court, can I help you? It's like, no, can you please direct me to the Federal Court? I have no business with the United States District Court today. Thank you. And I'm going to want them to send me over to the Federal Court. It's the same thing with Federal Express or UPS. Do I want to deal with the United States Postal Service or do I want Federal Express? I'm going to call up Federal Express, and all of a sudden the lady says, UPS, can I help you? It's like, no, Federal Express. Oh, we're the same thing. What do you mean we're the same thing? Oh, we deliver packages overnight too. So you're Federal Express? Well, yeah, sure. Fine. What do you need from us? I need somebody to come here and pick up my package and deliver it overnight. It's like, okay, just mail us $350. We'll be there and mail it to China for you overnight. Okay. A guy pulls up in my driveway, it's UPS. It's like, whoa. It's at Federal Express. He says, you know what, it's the same thing. And no, we're not. I got an account with Federal. What are you doing? I wrote a check. How did you guys cash it? I know I wrote it. You guys cashed it? How did you guys cash it? So see, I actually glad that they cashed the check that I wrote out to the Federal Court and the United States District Court, a corporation, filled it out and cashed it. How? What do you mean you put it in the United States person's account? Whoa. That's theft of services. You know what? You better move my claim back over onto the right side of the court, and you better leave it as a tort injury claim, and I better hear no more nonsense out of you. I'm going to sue you people for all that $350. So see, I actually like the fact that they put the $350 into the wrong account. They put it on the United States District Court account. I didn't write no check, no money order to them. I clearly wrote it out to the Federal Court. How are you people cashing a check that I wrote out to some other person? You're totally two different persons. The Federal Court is one, I don't even know. Federal Court is more of a concept than a person. It's you agree, it's all lowercase, so it reserves all rights and remedies. It's lowercase. I don't know if you guys know anything. Capitis, minimus, capitis, maximus. I said, but it reserves all right as a federal court. Now, if I didn't use no uppercase F and no uppercase C. Because like I said, that first order the magistrate wrote, he says the court has concerns with propriety of this case. And I called up the governor's attorney, and I talked to him for half an hour, 31 minutes. And I said to him, do you realize this magistrate wrote an order, and he's got 4 different jurisdictions going on in a one paragraph? I said, which jurisdiction do you believe I'm moving under? He says, your own personal jurisdiction and under the common law. I said, yeah, bingo. I said, I'm so glad the governor's got a smart attorney. I said, this guy's got civil, he's running me under some sort of civil administrative code and under some sort of federal rules of civil procedure, and then he's got his own personal jurisdiction going under there where he says, the court has concerns of propriety, of ownership. I said, it's all lowercase. So when he says the court has concerns of propriety, that means he believes he is the court. So he believes it's his personal decision. He has no rights to any of this. He didn't write the damn claim. I did. So it's so funny, man, that the governor has a really smart attorney, man. His name's Franklin Johnson, and he can keep up with me. And I've never had an attorney or FBI agent or anybody who can keep up with me. And this Franklin Johnson guy works for the governor's office. He's good. He followed me through that whole damn order, man, without blinking an eye. He did really good. Because, like I said, Greg is a good guy. He loves researching. And I'm sure that someday he's going to understand exactly what I wrote in my long 4-page lawsuit. But this 1-page lawsuit, oh yeah, I'm sure Greg pretty well understands this 1-page lawsuit. He helped me, tighten it up. I'm going to finish sending him the final copy that we were working on the other day. He never got the final copy yet either. So, yeah, but Greg's a great researcher, man. Can he tell you about all kinds of Queen of England, Pope stuff? Oh, you betcha. You know, he knows all that stuff. He researches the death out of everything. Me, I just want common law. I don't know nothing no more. I just want 1-page lawsuits, and I want to go home and do something else. I'm done. You know, I just want to get my remedy and go home.
Well, I think that's been the goal with all of us, but, you know, unfortunately, we've been in here since the 80s, and some people longer.
Right.
Yeah.
Right, but the beauty of the whole thing, Dan, is it's like we're not wrong. It's wrongly done.
Right.
And what we all tried to do, like if you grew up through the whole administrative process of setting up like 232 claims that you have to say yes or no to and catch you with your freaking pants down and while you were sipping on a mint julep, you know, and all that ridiculous long, 9-step process of administrative process and everything, which effectively is lawful in commerce, is lawful in admiralty, you know, you do all kinds of stuff with it. You know, I foreclosed on the bank on my mortgage with that process, you know, and they can't move. You know, we got them locked down, and I've got a $5 million lien on them.
Oh, man.
It doesn't mean that I've got anything for it. It does mean that they can't take the house, but it basically leaves the entire process in limbo, so that nobody can do anything, and everybody is stuck in stalemate. Because
can you give a little more detail?
Even though we had a 3-member notary panel, pass final judgment on it, which should be accepted as the law of the land, we can't get a county court to rubber stamp it to say, yes, it is. Because if they do that, then that kind of like tells everybody that they can do that. So the county courts are running away from the lawful response that they're supposed to do. So, the good news is that I don't have to pay a mortgage and I've got my house for the rest of my life. The bad news is I can't collect on the fraud. So that's kind of okay. But the whole thing is that we were all trained to do a whole bunch of stuff in one set of documents. All right? And the problem is that when we send somebody 100 pages or 12 pages or whatever, they don't freaking read it. They think that you're nuts. Now, Visa or MasterCard, Chase Manhattan can send you 12 pages, and they go, well, why didn't you read it? You're obliged to. But, when an ordinary man sends something back into the court or to a creditor, it's unreasonable. Why? I don't know. It's part of the game. So Karl's approach is break it down to one claim per page. If you've got 300 claims, send them 300 claims. Don't send them one claim with 300 claims on it. Right? Send them one page for every damn claim. Now, they can throw each one out or keep each one at a time. So, you're going to tell me they can't read 3 sentences on one piece of paper. Now that's
I think Gene had a question for you.
Yeah, I do have. I'd like you to back up on that foreclosure part. And how did you, again, this is post-judgment, after summary judgment, how did you tie that house up to where they could not take it from you?
We proved the fraud. We proved the claim that they didn't loan any money, that I created the funds by my signature, and that they entered that stuff on the account, and I basically loaned myself the money. And we went through their attorneys who refused to respond, and we gave them, it took 2 years. It took 2 years of due diligence.
You did it administratively?
Yeah.
Okay.
Now, Gene,
when we finally got done, we entered the whole thing on the county record, and now the U.S. Bank and their attorneys are stuck.
Yeah, but see, this is what I was saying. This is what Billy Thornton and everybody's stuck on. Everybody's stuck on this last part to force the court to sign a damn judgments and give them back to us.
Right.
So this is what I'm saying. This is what I'm working on, and I showed. Thank God, you guys don't have to stick your neck out. I already did, and I already got the blessing from the U.S. Marshals to try it. They said, what are you going to do? I'm going after the public goals. And then what are you going to do? I'm going after their public bonds. And they're like, well, what? I said, look, this isn't paper terrorism. I got it out of this book. I'm following this step, this step, this step. Look, I'm doing it out of their book. So I said, yes, you're going to get a call from them in about a week or two saying that I'm doing all this nonsense and I'm interfering with the proper flow of justice, or I'm threatening because if you take the bond, you close the whole court down. He said, they're going to say that I'm, threatening to disrupt the government by using paper to disrupt, to interrupt the proper flow of government. That's what terrorism means. It means something about using something to interrupt with the proper function. That's it, the proper function of government. So they're going to make a claim that I'm interrupting with the function of government. So, I said, look, he said, well, at least we know who you are now, and, you showed us what we're going to do, and it's step by step, and you're following the law, and we see exactly how you're doing it. You're not going to use any of this crazy site draft stuff or that. What is that clown, Gordon Hall nonsense? You're not going to do any of that crazy crap. And like I said, that guy got off cheap. Only Gordon charging him $10,000. He usually charges people $20,000.
Sure it is.
Oh yeah, it's ridiculous, man. And then he's, and this one guy, man, he was on Greg heard the call, and Gordon Hall promised that he wouldn't swear across at anybody ever again. And then I was the second caller, and then he looked at me like a drunk sailor. Because I just tried to say to him, like, I said to him, thank you very much, Gordon Hall. You did help me a couple of years ago, and you explained to me how to ask for compensation and how to hold my claim for compensation. He just said, thank you for showing me that. I said, but all this silly, like, side draft stuff, come on. I said, this is why I got all those guys in Montana thrown away in jail for the rest of their lives. Why are you teaching these people how to do this? He says, well, it works in the form of, oh, Greg, you missed that part of the call. Ben asked me, he says, I got somebody paid Gordon Hall, or maybe you heard it, where he was saying Gordon Hall charged a guy $10,000, and now the guy's in all kinds of trouble.
Well, it was a secondary guy that got in trouble, and I'm not familiar with what Gordon does. I have no idea what he does, and I'm not trying to bash him. I'm just stating that the guy did pay him $10,000 in property, and he sat there for over a year in jail. And whatever they did, it did not work. Now, the problem possibly could have been the guy that hired him actually had an injured party. He had a complainant. He was accused of stealing some equipment. He didn't steal the equipment. It should have only been a civil action between the two parties, but because of his some of his arguments, he inflamed the cops and the court, and I believe that's what made it worse on him.
Right, because what it was is one guy, he was a tugboat captain, and he asked me my opinion. And what I told him was like, because I used to work for Sony and Dell, a computer company in Vegas, and I was tech support. So people in the 90s, when this stuff first started coming out, it's like, well, how do we deal with when the federal government, if somebody says that there's kiddie porn on my computer, how do I protect myself from that nonsense? And I said, look, the federal law is they must bring somebody in court, open court, under oath of affirmation, and can prove that you viewed it. Just because it's on your computer, on your hard drive, they can't get a conviction on you. They have to have somebody who's going to stand up in court, swear in open court that they watched you view it. I said 99% of the times, you clowns get yourselves in trouble, say, yeah, I had kiddie porn on there, I know I should have got rid of it. So then you're going to turn state's witness on yourself when you should have held the Fifth Amendment right and not vote, testimony against yourself. I said, so people were asking me this back in the 90s, so I told the guy, I said, just say, does the state have anybody who's going to come forth under oath of affirmation and prove that that I viewed this? And the guy was like, so then he went over to the Gordon Hall people, and they charged him $20,000. So when he's a tugboat captain, so what's funny is he said he did the Gordon Hall speech beautifully, and this was like on the late October show. He says, I go to North Carolina court, and I talk to the North Carolina judge. He said, upon a proof claim of a certified claim, party evidence, whatever Gordon Hall tells everybody to say. Upon bona fide proof of a claim, da-da-da-da-da-da. So he says the thing's beautiful, and Gordon Hall's like, see, people, you can just keep saying the thing over and over again, and it's successful. And then he says, near about an hour into the show, the guy from North Carolina says, and then I handed the judge a $2 million side draft. And then he said the judge just started to smile. And he says, are you for real? He says, yes, sir, I'm very for real. What are you talking about? He says, what is this? He says, it's a site draft. And the judge said, and you want to do what with it? He says, that's how I'm going to pay the debt to the court. He says, okay, and this is real? He says, yes, it's real. So see, the judge got him to believe that he believed it was believed because he believes it was real. So he says, okay, that's fine. He says, you can leave now. We're done. So then he said the next week, Gordon Hall, I said, why don't you tell what's happened to the man in North Carolina? I said, I know what happened. You want to tell him what happened? He says, well, our hero had a little bit of a little dilemma with the legal system down there. It seems like the sheriff deputies appeared on his front door, and they knocked on his front door. And while his wife had the sheriff's department busy, he ran out the back door, and since he's a tugboat captain, he's out at sea now. So, but they wanted him to come down to the sheriff's department to, clear some of the, the conditions, in terms of the conditions that he proposed to the court. I was like, yeah, go ahead and you keep saying that, man. I know it's a site draft. You don't hand a judge $2 million site draft because the court wasn't asking for $2 million bonds or damages. And whatever the court was only asking for $100 in damages, well, you're going to ask the court for $1 million in change? I say, that's not money. I said, the court doesn't accept it as value for having money. I said, that's like me saying to my neighbor on my farm, saying, I'll give you 2 tons of cow manure if you give me 3 bales of hay, because that's equal value. That's what we believe is money, and that's what we transfer sometimes between the guys who have the hay and the guys who have the cow manure. So, but you can't dump 2 tons of cow manure on a court porch and say to the judge, well, that's worth 3 bales of hay, which is about $50. You don't accept my 3 tons of cow manure? Well, no, that's obscene. That's ridiculous. Get this shit out of here. Get this shit out of here. So I said, you can't just hand somebody a site draft if he doesn't accept it for value. You have to make the conditions known to the person, like, I would like to pay you with a site draft. Is that permitted by the court? Does that go against any rules of the court? Can you allow me to make such an offer or tender such a payment to the court? And get the court's permission.
There you go. That would have been much better.
You can't just hand these people these crazy things and just expect them to accept them. Oh, well, it's a process, and they follow the rules, I said, bullshit. If you tried to hand, I said, Gordon, how about I retain you for $20,000, and I hand you a $21,000 site draft, and I tell you to mail me back $1,000 in green cash. You're going to tell me to stick it and blow it. Just wait a second, that's money. I just generated it out of thin air. Look, I used all the birth certificate and the Social Security Act, and I sent the K Trust Act, and I talked to the Queen, and the Pope signed the paper, and we're good to go. I said, you're going to tell me to stick it. So...
Well, even if they were even if they were legitimate, they're simply not going to allow you to accept it because their whole system's going to collapse.
I want to take it. If you owe me a side draft, I'd laugh at you. I'm not going to give you cow manure for it. Can I wipe my ass with that side draft for 1 pound of cow manure? Maybe. Okay, maybe I'll give it to a pound of cow manure because I'll use it, make it a fire in my stove. But other than that, I don't. What are you going to do with your side draft? What am I going to do with it?
Hey, Gene, you were asking about the administrative side on the house deal. That is what Robert Schaefer is doing, though, with that offer to pay. That offer to pay, what he's doing is he's basically setting the bank up. He's even done that on actions where the bank had already bought, supposedly, the property through the foreclosure sale. If you can get them to bite on your letter asking them to send you a complete accounting, a complete billing of what's owed even after the sale, and they bite and tender that bill, that's when he starts his notifications back to him, where he starts to set them up. He doesn't do it all in one step. I believe it's like a 4 or 5 stage notices that first you get the billing, then you give them the offer to pay, and then once they accept that, then you start setting the conditions. Okay, I will tender the full amount, but you, as a holder in due course, are required to bring the original note still attached to the deed of trust, and and whatever the other issues are that he raises, and I'm not familiar with all of them because he hasn't brought them up yet. Then after that, then he starts getting into the new money argument using the Federal Reserve pamphlets where they describe the issue of the new money. And so then he uses Title 31, 742 as moved to 3174 in that they can't demand obligations of the U.S., which is a Federal Reserve note. And so he tangles them up, and he says that he has never lost nobody has had to move yet, and he's been doing this, I guess, for quite some time.
You want to hear something even funnier that you can do? Because I'm older and Greg's older. I know Greg's going to be punching 50. I'm punching 50. But during the 1980s, women were getting divorced from men like crazy. So the husbands were like, well, why should I give them any money? They never went to work. So what the women would say is like, but wait a second. If you had to hire a babysitter $2 an hour, 24 hours a day times 365 times 11 years, that means that's $72,000 that you would have had to pay out of pocket to provide for your kid if I dropped dead and died. So what a lot of people are doing with these home foreclosures and things, say, fine, would you like to take back over control of this house? Yeah, great, wonderful. Well then, you say, so what do you do to them? You say, well, the only problem is I put $30,000 worth of signing on it. I put $10,000 of landscaping into it. I mowed the lawn 15 times a summer for 15 years, which comes out to X amount of dollars, $20,000. I put up gutters and leaders in the water system. I put in the underground pool. So this is what they were doing up in New York. They sold you a house for $100,000. You put $300,000 of improvement into it. They can take the $100,000 house because they're the one who moved the claim. You tell them, fine, take the freaking house. Now, I'm making another claim in court for $300,000. Since you're the asshole who started the claim process, you got it now. You're the one who started the crap. Give me $200,000 and you can have the house. That's what husband and wives are doing through divorces in the 80s. Like, you're the asshole who filed the divorce. I showed the court and proved that babysitting services, housekeeping services, running grocery store errands for you. Remember, Greg, how women were doing that? Yeah.
Well, people were attempting that, but the courts were simply ignoring their sweat equity claims.
Say, Judge, you ignore that? I'm going to rip that aluminum siding out. I'm going to remove the paint off the side of the building. I'm going to sell the landscaping. I'm going to send the landscaping for $2 to any Mexican from Home Depot who wants to take it. This house is going to look like a shambles, man, when I'm done with it. There's not a damn thing that bank can do to stop me either, because it's still mine. And that's my property that I put into it. That's my money I put into it. So if that fucking bank wants to see an empty shell of a house, I'm going to lose it anyway. You know what? I'll sell it for $50 to the Mexicans, and they can take every damn thing out of it.
Yeah.
And see, they knew New Yorkers like me. We're nuts. We'd actually do it. We don't care. And the whole New York thing was like, holy crap, these New York people are crazy. It's like, hey, it's not going to be my house no more, so screw it. You know what? I'll get the guys down at Home Depot and say, hey, you want free lights, free plumbing, free facade? You want to sell it to your buddies? Come and get it.
It's really surprising that more people don't actually do that.
Well, New Yorkers, we're crazy. We'll do that. We'll say, you know what? I'd rather sell this house for $5 than let a bank walk off with it.
Right.
We're just crazy like that. It's like, you're not getting out of this. No, I put too much money. I put $300,000 into this $100,000 house. You ain't getting a $500,000 house for $100,000. It ain't happening.
Well, before you came on, I was talking about there's a fellow named Paul that was up in the state of Washington, and he went in and he was trying to record a proper deed. One of the things that they're doing is when you bought your property, the fiduciary trustees that you hired to transfer the property into your name failed to adequately preserve the interest in the deed, in that they did not include an acceptance and acknowledgement. And so there's actually a different acceptance and acknowledgement for corporate or private property. And so that acceptance and acknowledgement is what shows the county whether it's subject to property tax, because only corporate-owned property is subject to property tax. So by omitting that, they've automatically set up the accounts once that deed is recorded. And so this fellow in Washington, his name is Paul. I don't recall his last name. Went into his county recorder. Of course, Washington I believe does not have property tax. I know they were talking about voting it in up there, because I'm actually originally from Milwaukee, Oregon, and I have a lot of relatives in Washington. But so anyhow, he was simply going in to correct his deed. And so because a lot of people are doing this across the nation, and a lot of the counties were automatically pulling the property off the tax rolls when they recorded a proper deed with the acceptance and acknowledgement. So he was in there talking to his county recorder, and he told her, I'm here to record a new deed. And she said, you can't do that. You already have a deed on file. And so he said, I was talking to her really polite and trying to explain to her that, yes, you're correct, but this is my private property. I am a people. I'm one of the people. I'm private. This is my private property, and this is my private deed. And there was an omission on my deed. They did not put the acceptance and the acknowledgement, which is a requirement for deeds. So all I'm trying to do is record a new deed on my private property. And you, as the county recorder, have a fiduciary duty to the people to record our instruments. Actually, they have no authority to tell you whether or not your information is proper. If you file a deed or any instrument that violates somebody else, they would have a claim against you, not the county recorder. But anyhow, so as he was talking to her, he said, all of a sudden she backed up a couple steps, and she started mumbling to herself, private, one of the people, private property. Oh, okay, I understand. So she goes ahead, I believe she goes ahead and records his deed. Then she tells them, oh, you need to go downstairs and pay the excise tax. And that's another thing we were talking about earlier. I actually picked up the act for California. It's the 1857 General Revenue Act that created the excise tax on negotiable instruments. So, and it has a fee schedule depending on the value of the negotiable instrument. So he had no idea of this. So he followed her instructions, went downstairs, paid the excise tax, and then went home. Within 2 weeks, he did state that he actually had 2 notes. And so he paid the excise tax on both of them. Within 2 weeks, he received in the mail from his bank 2 releases of liens. And he goes on to state on that call, I did not pay off the note. I did not notify the bank that I recorded a new deed or paid the excise tax. So the question becomes, is it the lien actually on failure to pay the excise tax and actually has nothing to do with the note? Because in the mortgage contract, they tell you that you are responsible for the taxes, but they don't tell you what taxes they're talking about. And obviously, if it's a private property, because the 1857 General Revenue Act, even on the side note, says that its application, property tax, is for corporations. Then I have a 1920 Political Code of California, and it says in it on Section 91 that exemptions of private property under the General Revenue Act of 1857 as amended in 1859, statutes 1859, page 343, so far as it includes private property, is in violation of the Constitution. And that's People versus McCreary, MCCREERY, 34 Cal 40, page 452 to 457.
Let me break that up for a second, because there's a lot of this was happening during Farm Aid for the farmers back in the late 70s, early 80s. I don't know how old you are. But anytime there's a transfer of title that these farmers were getting themselves involved with, like you're saying, taking it over from you as the person to you as the man, if that's considered a transfer of title to another person, everybody knows it's ancient law that this man better be careful. Like I said, you could ask this man, you say, has the bank requested an acceleration of the payment? Because once, if I had a mortgage with a bank in this house, and I sold it to my neighbor, they would demand from me every damn dime that's owed on this house from me immediately. So it's called acceleration. You could Google that if you want to later on, find acceleration of the debt.
Right.
They say bank mortgage. So when you transfer something in the county office like that, and I'm not, like I said, I'm not sure exactly what you're talking about, deed compared to title, and I'm not sure if there's a difference, but I know the quiet title things are crazy, because if you transfer title from one person to another, the bank has every right to accelerate the payment on the debt, and you have to pay them every damn thing within like 72 hours or 24 hours.
Yeah, but see, that didn't happen to him. All he did was go into the county to record, to correct an error, and they mailed him the release lien.
The county did it with him, right? Like, well, when the
No, the treasurer must have notified the bank, and the bank sent him release of lien.
Yeah, that's a good question, man. There's a release of a lien, like a forgiveness of the debt, like a forgiveness of the note of the mortgage. I mean,
well, he said that they haven't been billing him anymore.
Yeah.
So it is a strange event. I'm not saying that is in fact, that if you pay excise tax, the bank is going to give you the property. I'm not saying that at all. I'm just saying that's what happened to him. And I am saying that it is, in law, a requirement that an excise tax is applicable to a note.
Right. That's what I'm saying.
Now, what I did find was that act is listed on the Board of Equalization's online manual to this day. That's where the Board of Equalization derived their authority, and it is in the amended act.
Right.
So, anyhow, it's a very interesting deal.
Right.
And what's funny is he had no idea. He didn't know that he owed an excise tax. He didn't know nothing about it, but I had been digging on that side of it for a long time. In fact, I had been trying to get that act for quite a while, because I've had this 1920 code for about 2 years, but I couldn't find that act. I couldn't find it online. HSU, that is a repository for California law, didn't have it. And so finally, scratching my head, I thought, well, hell, I'll just email Sacramento County Capital, the Capital Law Library, and for $2 they scanned it and sent it to me. Now I found out that I probably could have found it on the state library, California State Library archives, because I've emailed those librarians and they've been sending me information showing me how to go through their archives. And so you can find all these types of old acts through either the state library or the Secretary of State archives. And that's where you get the certified copies, if you want them, is from the Secretary of State archives.
Yeah, but what I'm saying is, even like Greg can tell you, I think it's called the Green River case, the Green Valley case. Greg from, South Dakota? That famous case from it started in 1957, went all the way to the Supreme Court, where the man proved that the bank never loaned him any money to begin with.
Oh, yeah, the Credit River case.
Right. So what's funny, Greg will even tell you that what's funny is it works for the first guy, and then the banking system and the judges all get together, and it's harder for the second guy to do it, and then the third guy who does it, who tries to rely upon that Green River Act, whatever?
Credit River case, yeah. Well, that was actually overturned later on. So
right. That's what I'm saying. Right, so that's what I'm saying. The first guy might slip through under the radar. They will, since it's all commerce and all administrative codes, and they build it upon codes, and they don't use common law,
common law stays true from caveman times. Common law has never changed. Any harm, any loss, any breach of contract. No. Okay. You got no case.
Well, here's another thing that Robert Schaefer does is he also incorporates the land patent because he uses the forever clause in the land patent, and he shows that in the mortgage contract, you never gave up all right, title, and possession to the land by getting a mortgage, and so he uses the forever clause in the land patent also within those bundle of notices that he sent into the bank. Basically what he does is he just traps them from all angles. And
right, well, like I said, that's what I'm saying. It's funny. It's like I said, you just said it again, like they were Green River.